Okay, welcome everybody. We're going to get started. I'm Mark Lemley. I am a professor here at Stanford Law School, and I run our program in law science and technology. You'll hear from me later on the substance of this issue. But for now, all I really want to do is to thank you all for coming, welcome you to Stanford, welcome our distinguished guests from Washington, and to apologize for the weather, which is really not California normal. But beyond that, I'm just going to turn it over. I think we're going to hear first from Meredith Schoenfeld, who's the associate solicitor in the Office of Solicitor General.
Thank you. Thank you, Mark. And good morning, everyone, and welcome to the USPTO West Coast listening session on AI inventorship. It's great to have you all here, both in person and those of you watching online. We really appreciate everyone's participation in today's listening session. 2 weeks ago, we held a East Coast listening session, which will be available online to watch. And many speakers in that session explained that AI is being used in ways that are already testing the boundaries of the current patent system and have urged the USPTO to be very thoughtful in its approach. So our takeaways from today will shape our future work on AI policy at the USPTO and will also inform the broader US government's approach to these critical technologies. We are very delighted to be here today at Stanford University. Stanford University, as I'm sure everyone knows, has made very significant contributions to the field of artificial intelligence, including the development of deep learning algorithms that power modern AI applications. We would like to give a very special thanks to Professor Mark Lemley, to Giselle Darwish-Brown, and to Jody Carrion from Stanford Law School today for all of their efforts in organizing, supporting, and hosting today's session. So I'm going to give just a brief overview of the agenda for everybody. And we're going to start with some recorded remarks from the director of the PTO from Alexandria, Kathy Vidal. And then we're going to go have a few brief presentations. Matt Sked from the Office of Patent Legal Administration will be giving an overview of the request for comments and some of the questions and work that the PTO has done. Then I'm going to give some hypotheticals based on case law so that we can kind of just get our brains focused on what AI looks like, what joint inventorship looks like, and some of the questions that we'll be handling. Then Professor Daniel Ho will be giving a talk about Stanford's artificial intelligence work. Then we'll have a brief break and get into the speakers. So we'll have a first listening session, a lunch break, then we'll have a brief overview of the Journal of Patent and Trademark Office Society. We'll have the second listening session with a number of speakers, and then we will have the closing remarks. So I now just wanted to give a brief introduction to the PTO personnel that are here today. We have myself, as Mark said, I'm the associate solicitor at the USPTO. So I work mostly on federal circuit appeals, and I'm also a member of the Artificial Intelligence Working Group. We have Charles Kim, who is the director from the Office of Petitions. We have Matt Sked, who's a senior legal advisor from the Office of Patent Legal Administration. We have Alex Kersner, who's a supervisory patent examiner. This panel will be asking questions of the speakers. We also have Steve Koziel, who's the acting director of the Silicon Valley regional office. And then we will have Josh Schwartz, who is the executive director of the Journal of Patent and Trademark Office Society. And just a few reminders, during the public listening session, each speaker will have 7 minutes to speak, and we will provide you with a 1-minute warning. At the end of that 7 minutes, the panel will ask questions for about 3 minutes. Unfortunately, because of the timing, we cannot take questions from the audience, so the questions will be just from the panel up here. We do have a tight schedule, so please, everyone, try to keep on track as much as we can so we can have our lunch and breaks. Then, of course, as always, make sure your cell phones are silenced. And for the in-person speakers, We will give a little introduction to you at the time of your remarks. For the virtual speakers, you will be able to be unmuted when your remarks come, and I believe that there's mostly in-person speakers and then 2 virtual speakers. So now we will hear from Kathy Vidal, the recorded video remarks, and thank you again for coming.
Welcome, everyone, and thank you for joining us both in person and online. Your participation in today's listening session is extremely important in helping us determine how we as an agency, the U.S. Patent and Trademark Office, and all of us collectively as a nation can stay on the forefront of one of the most transformational technologies ever created. With most of our industries having been digitized, including our entire patent and trademark system, we are entering a new era of innovation. At the USPTO, AI is already being responsibly deployed throughout our operations. We are also experiencing a surge of new patent applications utilizing AI in more than half of our technology centers. In fact, in 2020, we received more than 80,000 applications that involved some aspect of AI. This was 50% higher than in 2002. AI now appears in 18% of all utility patent applications and in more than 50% of all the technologies that we examine at the USPTO. This data reinforces that AI is important in innovation in all industries and from all regions of our country. At the USPTO, we have a highly skilled staff of AI experts with experience in all aspects of the technology and its applications, including the technology's potential impact on the legal aspects of intellectual property protection. But we want to hear a diversity of views. Your experience is highly valued. We will listen and read your comments closely, as we always do, and we will act deliberatively with additional input from the public and in the best interests of our inventors and our country. Given recent developments and the current trajectory in AI innovation, we are presented with new issues that will need to be addressed. Most of you have seen the questions on AI inventorship that we have posted in the Federal Register on February 13th. We believe they get to the heart of the matter. In many cases, the answers are neither apparent nor are they simple. Patent offices and courts around the world are wrestling with these very same questions. So the perspectives you provide today will help us tremendously as we move forward to address AI-enabled innovation with policies that will encourage and incentivize both innovation and the protection of IP. We must do this without restricting advances that can be discovered with the use of AI. I invite all of you here in person today and all of you who have tuned in virtually to provide us with written comments generated from today's discussion. We really appreciate your engagement. Thank you again for your participation in today's listening session.
So our next presentation, we will have an overview of the AI RFC from Matt Sked, who is a senior legal advisor in the Office of Patent Legal Administration. Thank you, Matt.
Hey, good morning, everybody. How you doing? Let's make sure I have this working. All right, let's go. All right. How you doing? As Meredith pointed out, my name is Matthew Sked. I work in the Office of Patent Legal Administration. That's our policy shop at the USPTO. And that's a good thing because I'm here to talk about policy today and where we're going here with our request for comments. So what I want to talk about for next 15 minutes or so is I'm trying to set the table a little bit for what we're going to be hearing throughout the day from everyone else. So I'm going to go over our artificial intelligence emerging technology partnership that we have going on. And I'll start discussing the Thaler versus Vidal case. I'm sure most of you are pretty familiar with that by now, but I'll just, for posterity's sake, I will go through that a little bit. And then finally, I'll talk about our request for comments and what we're trying to do with this request for comments. Okay, so we have a artificial intelligence emerging technology partnership. We started it last year in June, so we're almost at our first birthday of it. And we had our first event back in June of last year as well. So what this partnership is really trying to do is the USPTO partnering with its stakeholders, the IP community, to try to figure out, we have a lot of new issues coming at us, right? The artificial intelligence, all these new emerging technologies like blockchain, quantum mechanics, all these sorts of things. And it's posing new questions to us that we never really had to consider before. And so we want to partner with the community to understand, what are the questions we should be asking? Are we asking the right questions? What are the answers to these questions? And what should a PTO be doing at the forefront of this? Okay, and so that's why we have this partnership. We started this partnership. So over this past year, we've had several different meetings with regards to this. The first one was in June last year, I mentioned. In that meeting, we talked about inventorship. We talked about subject matter eligibility. We talked about disclosure practice with regards to AI and ET inventions. In September of last year, we had our first event having to do with biotech, specifically focused on AI and biotech. And February of this year, we had another event. It was our AI-driven innovation event. It was kind of, I see it as the precursor to these listening sessions. We talked about inventorship. We talked about where technology is today. And so as I'll talk about a little bit more, this listening session, this RC is really trying to dig down deep into these issues and really figure out where we should be. And I didn't mention that yet, but we did have a blockchain IP series as well. From between May and December, we had an event every month on blockchain, which covered all different subjects in there. I gave a talk on one of those events on subject matter eligibility. Okay, so now it leads us to inventorship, because that's what we're mostly focused on today. We are touching on some other issues, but most of it is inventorship. And it's really kind of been genesis by this Thaler versus Vidal case. As I said before, you're probably all very familiar, but this occurred back in July of 2019. Dr. Thaler filed a patent application with the USPTO. In his application data sheet, he identified the inventor as DABUS, which is, if I remember the acronym correctly, Device for Autonomous Bootstrapping Unified Sentience. I may have gotten that wrong, but I think I was pretty close. And so if you're not familiar with the patent application process, when applicants file applications, most applications come with this application data sheet where they filled in with all the inventor information, applicant information, all their benefit and priority claims, those sorts of things. And so this thing actually never got to an examiner. We never got to substantive examination of this application because it got held up in our pre-examination process. In our pre-examination process, that's when we go through an intake. We make sure the application is complete before we can even move it on to examination. And so they make sure the application data sheet's there, the specification there, claims there, they paid all their fees, et cetera, et cetera. And so this got flagged in our pre-examination process as not listing an inventor. So we sent out a notice to file missing parts saying, hey, you didn't list an inventor. You just listed this machine in the space for the inventorship. And they came back and said, no, that's what we meant. We believe this machine is the inventor. And we responded saying, well, we can't accept your application anyway. They didn't like that result, so they petitioned the director to overhaul our pre-exam unit. They asked us to reverse course. We had a few back and forth, and we eventually issued a final agency action where we took the position that an inventor had to be a human person. They did not like that, and they sued us in the Eastern District of Virginia, and we got upheld there as well. And finally, the CAFC affirmed us, finding that inventor must be a natural person. So talking a little bit about the decision, the Thaler versus Vidal decision. So statutorily, it comes down to 35 USC 115, right, which requires the applicant to identify the inventors and provide oath and declarations for all the inventors. Now, an inventor is defined in 35 USC 100F as an individual who invents. An individual is the crux there. What is an individual? And that's what the Federal Circuit really had to kind of figure out. And so they went back to look at some Supreme Court case law, identified that an individual is a person, a natural person, unless Congress has showed strong intent to change that meaning. And since they did not find any strong intent from Congress to change that meaning within the meanings of 35 USC, they upheld it that it had to be a natural person. Now, so the conclusion of the court is that an inventor must be a natural person. So just as important as what the court found, the court also did not address one particular issue, an important issue, is that whether human beings who are inventing and use AI to assist them in the creation of their invention or creation of their product, are these patentable? It's an important question they didn't answer, and that's kind of what the crux of what we're getting to today. So after the Federal Circuit, they asked for en banc hearing, that was denied, and then just a week and a half ago, their petition for cert was denied as well. So now that's where it leaves us in trying to figure out where do we move forward from Thaler, where do we go? So currently, as I already said before, inventorship law is that an invention created solely by a machine is not patentable, right? Cannot be patentable. And our regulations today at the USPTO pretty much support that. We have discussions in 2109, 2138 of our manual, pretty much saying that already. But we've been hearing from the community over the past year that AI is contributing more and more to the inventions, and we have to kind of figure out what's going on. So as I said before, we know the ends of the spectrum, right? We know something that's completely invented by a human, that is patentable, right? Assuming it meets all other patentability requirements. Something that's just conceived by humans, that's patentable. On the opposite end of that spectrum, we know something that's completely conceived by a machine is not patentable, right? But we have a whole spectrum of behavior that occurs between those two things, right? Where inventors are using AI in all different capacities to come up with new inventions and create things and design their products. And so that's what we're focused on, is that spectrum of behavior and focusing on several different things in that spectrum, right? So we have this request for comments, and we're trying to figure out, okay, where is technology today in that spectrum? How are inventors using this technology in their inventions? And where do we see that in the near future, right? We need to kind of know that to understand where our policy needs to be, right? And we also need to look at it from a legal perspective as well. These things in this spectrum, what is patentable, what's not patentable today? What do we think the law stands on these things, right? It's not very clear, but where should the PTO take a position on? Should the PTO take a position on that, and what should that position be? We also have to look at some ancillary issues such as ownership and things like that. We're also looking at not only where is the law today and where's technology today, where is it going in the future? And where should, what is PTO's role in that, right? Obviously, we can't pass laws, but we do have some sway in the IP community, and where should we be helping the policy and things like that as we move forward in the future. So those are the issues we're trying to get to at this request for comments. And so we're kind of trying to interact with the community in several different ways. The first one is stakeholder engagement sessions. That's today. We have several listening sessions. We already did our East Coast one last week. This is our West Coast one. We have collaborations with academia, where we're reaching out to different academics on these issues, as well as part of our Journal of the Patent and Trademark Office Society, which is a special journal put on by some patent examiners at the USPTO. They're going to have their own journal, specifically designed for inventorship and just this issue. So we're accepting, and Joshua Schwartz, I believe his name was, is going to come today, and I was going to speak today on that. And then we have the request for comments, right? The last part. So even if you didn't have a chance to speak today, or didn't have a chance to speak at the listening session last week, we do encourage you to please submit your comments. It's up on regulations.gov. We do read those. They don't just go into an abyss, never to be seen again. I guarantee you, we read every single one of those, and they really highly inform us as we move forward, as we brief the undersecretary and everyone else of how we're going to move forward here at the PTO. So we really do appreciate. We know it takes your time, your individual time to write those comments and submit them to us. We do appreciate that, and we do read them, and we thank you very much for that. So real quickly on some of the questions that we've asked in this RFC that we'll be hearing about today from our speakers. The first two kind of get to that issue I talked about before, is where is technology at today in the spectrum, right? How are innovators using AI when they're coming up with their inventions, and how significant are these contributions these AIs are making, right? The next one is, AI at its core, right, is software running on a processor. How do we differ the use of AI from other software inventions or other inventions as well? Can we treat them the same way? Should we treat them some special way? Those sorts of things. Question 3 starts getting us into the legal policy issues, right? How should we be looking at these issues from a legal perspective? 3 is looking at how should we be interpreting the statutes in this area, right? So the first one is just one potential way we could have interpreted statutes, and that's essentially saying, 115 requires the listing of inventors and an oath and declaration for inventors, and we know from the Thaler decision, inventors are human beings. So the statute in some ways could be interpreted as being silent with regards to contributors who are not humans. And what should the PTO do with that? Should the PTO just say, okay, well, it's silent, so they don't have to do anything? Or does it mean that silent, meaning anything that's not a human, automatically is not patentable, right? There's different ways we can take that. So that's just one interpretation, and seeing whether that's a reasonable interpretation or not. And are these interpretations, how these mesh with the Federal Circuit precedent, the court's precedent regarding conception practice? So those are some of the issues we're getting to with 3. 4 is is looking at ownership, right? As we all know, ownership vests in the inventors when they create their invention. So it's pretty straightforward. We know when someone invents, they're the inventors, and they can then assign those rights to anyone else. But when you have significant contributions from artificial intelligence machines, and they're contributing at a level that could be called a joint inventor if that person was a human, well, how does that impact ownership? Is it just the humans that contributed? Are they the only owners, or the people that help build the AI, or do they have ownership rights? The people who own the AI, do they have ownership rights? The people who actually interact with the AI, do they have ownership rights? Those are some of the issues we're trying to figure out with that. Question 5 is getting at potentially new practice we can have at the PTO, which is requiring applicants to disclose how AI was used in the creation of their invention, right? To get a better understanding of how it's currently being used, as well as to kind of inform the examiner when they're making inventorship determinations as to whether people who are actually being listed as the inventors are the inventors, and what kind of burden that might have on applicants, and whether we think this is a good thing in total. The next one gets to that one. Okay. And next is getting at incentivization. So this is next kind of questions are kind of moving into how we should proceed further at the USPTO as we're moving forward into this, right? And so how else should PTO be looking at AI-enabled innovation, and how should we be working to incentivize that, or should we be working to incentivize that? What things should the PTO do to mitigate harms that AI could be having? We've heard that in the East Coast listening session, some potential downsides of AI is that it could be flooding the office with patent applications, could be flooding the internet with prior art, these sort of things. What should the PTO be doing with regards to these potential harms that could affect the IP industry? And 9 gets to the statutory things that I talked about before. Obviously, we can't create new statutes, but where can we inform Congress when they ask for our opinions? What can we do to help creation of any new statutes of where we think IP should be? That's what we're getting at 9. And 10 or 11 is getting at first, what's everyone else in the world doing, right? We want to learn from how everyone else is doing. Is what they're doing successful? Is it not successful? What can we learn from what other countries are doing? And last but not least, what else should the PTO be looking at? We're looking at inventorship right now in these particular listening sessions, because that's the prominent issue right now, right? From the Thaler decision, that's just up front, and we know it's something that has to be addressed shortly, so that's why we're going at it. But what other things can the PTO or should we be focusing on, right? There's lots of issues out there. Where should we be putting our focus? Where should we be putting our efforts? We've heard about the issue of person of ordinary skill in the art, right? How does AI impact that? Because the fallout from that, how it impacts obviousness under 103, disclosure practice under 112, or all sorts of things like that. So these are things we're thinking about, and are we asking the right questions? What other issues aren't we thinking about you think we should be focusing on? So that's where we're trying to get to RFC. These are the issues we're hoping to learn from you. We really appreciate, again, that you're coming out today. Thank you very much, and we look forward to hearing from you. Oh, and by the way, these are some resources I have. This is our AI landing page, and some information up on that. I just put it up there for you. But I'll now turn it back over to Meredith.
Thank you very much. And just so that everyone knows, on the little program, we do have the questions on the back if people want to reference them again or just have them handy. So the next presentation we're going to go through is we're just going to talk about some hypotheticals that the PTO has been discussing that we've based on case laws. So they might sound a little bit familiar, the facts. The case law tells us that joint inventorship is one of the muddiest concepts in the muddy metaphysics of patent law. So it's definitely a complicated issue, and further complicated by the fact that an AI might be doing some of these steps as opposed to a human. So these are just some food for thought. So the first hypothetical, we have A, and A's dog has difficulty walking. A took the dog to veterinarian B. The problem was not improving. A then made a homemade harness similar to the commercial ones suggested by B. A thought the harness would work better if it was attached to the dog's toes. B suggested using a strap configured in a figure 8. A implemented that idea. The claims include the harness and the figure 8 loop. So now some questions for thought. So would A and B be joint inventors in this case? And if B had suggested a number of solutions and A had decided which one would actually be best, would they be joint inventors still, or would that change the situation? And if B was an AI, which we can certainly imagine, we can ask an AI, what would be a good way to attach to the dog's toes, and if B came up with that idea of a figure eight, would B be a joint inventor as well? So in the case that this is based on, it's the Verhoef case, and the A and B were joint inventors. So B was the veterinarian that came up with the figure eight, A was the man with the dog, and they were considered to be joint inventors. All right, in the second hypothetical, we have A discovered a unique receptor expressed on a variety of tumor cells and wanted to study its relationship to tumor growth. A then went on a quest to identify the ligands binding to the receptor. A began collaborating with B and C, and A, B, and C discovered two receptor binding ligands. That ligand binding disrupts immune cell detection of tumor cells, and that specialized antibodies to the ligand can block the inhibition of an immune response. This research was then published and shared. Later, claims to a method of treating tumors using the antibodies targeting the receptor and one of the ligands was filed. So here now, we would consider our A, B, and C joint inventors. And if B and C were AIs that were asked to find a binding ligand, would they also be joint inventors? And this case was based on the Dana-Farber Cancer Institute versus Ono Pharma Company case. And in that case, A, B, and C were considered to be joint inventors. So this case is, it's setting a standard for joint inventorship that is not that high necessarily. All right, our third hypothetical, A came up with an improvement to an apparatus for back projecting data provided by a scanner. The improvement was to add element X. A disclosed the idea of adding element X to company B. A then met with C, who was an employee of company B. A wrote parameters for a simulation and gave it to company B. C completed the design of the hardware to implement the simulation and was not allowed to make any changes to the system that A designed. A claim with element X was then filed. So now we ask, are A and C joint inventors? And if the situation were changed so that C was an AI that was asked to design that hardware structure, would C be a joint inventor? And would the answer change if C were able to make changes to the system? So this case is based on Seawall versus Walters. In that case, they actually were not found to be joint inventors because of the fact that there were no changes allowed to be made by C. But we can certainly imagine a situation in which an AI, would be able to make changes and come up with a solution. All right, the last hypothetical is a case that just came out. It's based on a case about bacon. So hopefully everyone's not too hungry yet because we're not quite at lunch. But A embarked on a noble journey to improve the process for cooking bacon and met with B to discuss cooking equipment. A did extensive testing and determined that a two-step process consisting of preheating the bacon in a microwave and then cooking the bacon in a steam oven yielded the best bacon. During the meetings, B had suggested preheating the oven in an infrared oven. The claim was to preheating the bacon in a microwave or in an infrared oven. So then the questions that we'll ask, were A and B joint inventors? Would B be a joint inventor if using an infrared oven was disclosed only as an alternative? And would B be a joint inventor if B were an AI and A had asked the best method to preheat bacon and B had suggested the claimed ways? So this case is based on HIP versus Hormel, and in this case, B was not a joint inventor because the infrared oven was determined to be basically an alternative and not the important part, a substantial part of the claimed method. But again, we can certainly imagine a scenario where an AI had thought of a method or had suggested a method that was more important to the claim and might, rise to the level of joint inventorship. So these are just some things to think about, and we thought those would be an interesting discussion for everybody. Sorry, I was just making sure that our next speaker was here. So we're going to hear, break, sorry. Sorry, we're gonna take a break now for 10 minutes, so we can reconvene at 10:40.
Dan's here. Do you want to?
Oh, okay, sorry. Sorry for the confusion.
Why don't you stay in the room?
Okay, sorry. Okay, so now our next transition, our next speaker will be from the Stanford Institute for Human-Centered Artificial Intelligence, and we'll hear from Professor Daniel Ho. Daniel Ho is the William Benjamin Scott and Luna M. Scott Professor of Law at Stanford Law School, Professor of Political Science, Senior Fellow at the Stanford Institute for Economic Policy Research, the Associate Director of the Stanford Institute for Human-Centered Artificial Intelligence, and Director of the Regulation, Evaluation, and Governance Lab, called the Reg Lab. Professor Ho serves as an appointed member to the National Artificial Intelligence Advisory Committee, the NIAC, advising the White House National AI Initiative Office, and as Senior Advisor on Responsible AI to the U.S. Department of Labor. He is also a member of the Committee on National Statistics of the National Academy of Science, Engineering, and Medicine, and a public member of the Administrative Conference of the United States. He received his JD from Yale Law School and his PhD from Harvard University, and clerked for Judge Stephen F. Williams on the U.S. Court of Appeals, District of Columbia Circuit. He is the recipient of numerous awards, including the John Bingham Holbert Award for Excellence in Teaching at the Stanford Law School, the Carol Hafner Award for the Best Paper at the International Conference on International Intelligence and Law, the Best Empirical Paper Prize from the American Law and Economics Review, and the Warren Miller Prize for the Best Paper Published in Political Analysis. So we're very honored to have Professor Ho speak to us today. Thank you for coming.
Well, thanks so much, Meredith, for that very generous introduction. As a law professor, I'm used to posing hypotheticals, not answering them, so I will not actually be addressing any of the hypos right now. But it's a pleasure to join such an esteemed group here today for this important listening session about AI inventorship. To begin, I can make one promise to you now. ChatGPT has not assisted in developing this speech in any fashion or form. This speech has been written down in a tangible medium of expression, and I claim human authorship and copyright. With that out of the way, I've been asked to say a few words about Stanford's Institute for Human-Centered AI. As Meredith said, I'm a professor here at Stanford, serve as Associate Director at Stanford High, and thought I would start off saying a little bit about High's mission and then articulate why I think the topic of today's listening session is so much at the core of what we think about at Stanford High, or the Stanford Institute for Human-Centered AI. Stanford High was founded in 2019 based on the recognition that the forefront of AI requires much deeper engagement with domain experts, disciplines, and approaches. Our mission is tripartite. Number one, that AI should be inspired by human intelligence. Number two, that AI should be guided by concern for its impact on human society. And that 3, AI should augment and not replace human capabilities. As one of the newest research institutes on campus, Stanford High has promoted work in research, education, and policy. On the research front, High has catalyzed interdisciplinary research such as work on intelligent wearable robotics to enable human mobility, modernizing tax administration with active learning principles, and research on foundation models like ChatGPT and DALL-E. I was really pleased that just earlier in the year, there was a delegation of the PTO here really to learn about rapid advances in AI medical imaging. On the education front, High has spurred the embedded ethics curriculum in computer science and a wide range of educational programs, such as the AI 101 series with the General Services Administration for government officials. And we hosted a congressional AI boot camp here, which brought a delegation of staffers to campus to really learn about all of the advances happening in AI. On the policy front, Stanford High has also been deeply involved in thinking about the innovation ecosystem. Along with 22 top computer science universities, we championed the National AI Research Resource, or the NARE, to level access to compute and data that is increasingly out of reach and really in the current environment only accessible by a very small number of industry players. In 2021, the US Congress authorized the NARE, the NARE task force. Stanford Law School hosted a policy practicum with about a dozen students to develop the blueprint for the NARE, and the federal task force completed its report earlier this year. High does a wide range of briefings for legislators, and I have the fortune to work with Meredith as a member of the NIAC, the National AI Advisory Commission, which held a public meeting here at Stanford last year. And the NIAC advises the White House on AI policy and issued its first year report just last week. At High, we think it's central that we envision a future where all stakeholders are empowered to shape the future of AI. And we think this listening session is a great exemplar of how government and academia can work together to create more opportunities for this kind of engagement. The topic of the day could not be more timely, as we have core questions about the future of AI raised by stunning advances in large language models that, at least to some, exhibit sparks of general intelligence. We've seen wide advances in the role of AI systems for scientific discovery of matrix operations and protein folding, as well as the ability of these foundation models to beat standardized testing benchmarks far above what humans appear to be capable, or what a wide range of humans appear to be capable of, not all humans. AI will only increase in importance to the innovation ecosystem, and the core question is whether and how the patent system should adapt to this changing scientific landscape. There are a myriad of really interesting legal questions at the intersection of AI and patent law raised in the USPTO's Federal Register notice and as raised in the series of hypos that Meredith just pointed you to now. I'll just touch on a few of these. The first is that the Dabus case presents one extreme where humans expressly disclaimed any contribution to the invention. The more likely path forward may really be in AI assistance. And if we think of a world where human-AI interactions and collaborations become more pervasive, how should patent law and policy handle such AI contributions? 2, how much of a structural change do we really need in existing patent law? Or can the law accommodate changes from the increasing reliance on AI? After all, the patent system has accommodated the use of other research tools, including those resulting in, quote, serendipitous or unforeseen inventions, end quote. Or put more vividly by some patent scholars, is the AI inventorship debate just, quote, seriously overblown, sensationalist, and a detraction from other more significant issues in the field? This is, of course, just a specific variant of the debate that we're having across regulatory fields, not just in cousins like the Copyright Office, but all other regulatory areas. Is this a call for simple regulatory adaptation or a broader structural change? For instance, to what extent can the Food and Drug Administration handle AI medical devices when approval has conventionally been predicated on a fixed device and software updates may scramble that notion? Or can the Equal Employment Opportunity Commission address claims of employment discrimination when AI tools can make it hard to conceive of intentional discrimination? And in the world of big data and AI, the distinction, it can blur the distinction between disparate treatment and disparate impact. And to what extent can the National Highway Transportation Safety Administration or the Department of Transportation handle the rise of self-driving cars under conventional mechanisms for setting motor vehicle safety standards and using its recall authority? Put more succinctly, does AI really need something unique? And three, to what extent does this matter at all for US technological competitiveness? Or as one commentator put it, quote, the main commercial players navigate the patent system without apparent concern about the issue of AI inventorship, end quote. At the same time, it's important that these conversations remain grounded in the technical realities of actual AI models and connected to the real human and societal impacts of AI. And so I'm just really pleased to see the lineup of speakers and engagement for the remainder of the day to really understand the reality of machine learning and how it intersects with patent protection. It's really exciting to be having this conversation at Stanford, where we prize interdisciplinarity and have the high program that brings together these sets of expertise across these domains. I could not imagine a timelier conversation, and I'm really looking forward to learning more from today's engagement, and I'm really glad to welcome you all here. Thank you.
Thank you very much for that talk, and we will now break till 11, where we'll begin the first listening session. I think we're ready to start with the first listening session. So we are very lucky to have as our first speaker, Professor Mark Lemley, who asked me not to read his impressive bio. But I'm sure everyone is aware of his credentials. So take it away, Mark.
Thank you. And thank you all for coming. I am very happy to be here. I think these are some really fascinating issues. I'm going to direct my comments to several of the questions, question 1, questions 3 and 4, question 6, and question 9. So question 1, how is AI transforming invention? I think there are a lot of different ways this is happening. And as Meredith indicated in her talk, they may have different consequences. So AI is definitely used as a tool in all kinds of invention. If you write code in Copilot, or with the assistance of Copilot, for instance, you're using AI as a tool. That's not necessarily going to create a patent problem unless the code itself is the thing that is claimed as inventive rather than some sort of a higher level software construct. I think there are other ways in which the AI itself is generating the idea, is generating the inventive output, often in ways that the human being did not contemplate. So the great example here is the fact that AI last year solved the protein folding problem. This is a common, significant problem that we have been working on sort of protein by protein for a decade. The AI didn't solve it for a protein, it solved it for all proteins. Now, maybe that's 20,000 patents, right? One on each protein. Maybe it's a broader concept, but in either event, it is not a concept that a person contributed to the world, right? The person didn't solve this problem, and merely saying, gee, I wish we could solve this problem, and then having a machine do it in a way that the person did not anticipate, I don't think makes that individual an inventor. If there's an inventor here, it is the AI. We've also got, I think, a coming problem of patent drafting. One of my colleagues, sort of as a sort of joke, asked an AI to write a patent claim, write a set of patent claims for an inflatable car. Now, you probably don't actually want an inflatable car. But the notable thing about this is not just that it wrote actually a very well drafted and structured sequence of independent and dependent claims, but that the AI, without any prompting, wrote into some of the dependent claims additional features of the inflatable car, such as the fact that it was modular and could be broken apart for easy storage. Those things show up in the claims. I think under the case law that Meredith just talked about, right, that makes the AI at least a co-inventor, even though it didn't come up with the overarching concept, because it contributes inventive portions of the claims. All right, so that takes us to questions 3 and 4. This might or might not be an ownership problem, right, in most cases, but it's going to be an inventorship problem. Thaler versus Vidal says an inventor can only be a person. I think that's a reasonable reading of the current statute, but that statute isn't going to age well. There is no human inventor in the protein folding case, and I think that issue is likely to become more common. There are going to be situations like the inflatable car case, in which even though there is a human inventor, not all of the inventive concepts come from the human inventor. Some of them come only from the machine. And I don't think it's sufficient to say that, well, we could just sort of ignore the contributions of the AI, right, or find a human somehow connected to this, and as long as there's a human, that's enough, right? It's not going to solve the problem in protein folding. There isn't a human who has done any of the inventive activity. And even in the inflatable car case, even if there's a co-inventor, co-inventors share ownership unless there is a contract to the otherwise. And we can't assume, I think, that the sort of ownership of the AI and the ownership and the individual will be the same. Sometimes they will be. Sometimes ownership is taken care of, but not always. And so I think if we pretend that the AI didn't invent when in fact it was participating in that invention, we end up changing the ownership dynamics as well as in a number of cases. So that leads me to question 6. Because of Thaler and because of this problem, people and companies will have very strong incentives to conceal the use of an AI in their invention. Right? That's particularly true where the AI did the whole thing, but I think it's also going to be true in the inflatable car case, right, where the AI contributes some part to of the patentable section. That's a problem. I think the PTO should adopt policies requiring an explanation of the use of the AI and what the AI contributed. And I think patent owners, while they might resist it because they don't want to sort of wander into this morass, are going to benefit ultimately from transparency on this issue. An inventor who conceals the fact that an AI did part or all of the inventive act is engaged in inequitable conduct, right? They are lying to the patent office about inventorship, and under the perceptive biosystems case, that is inequitable conduct. And their patent is invalid under Section 256 anyway. Right, so when you actually try to enforce that patent in litigation, you're going to run into a problem because it hasn't named the true inventors. Now, we changed Section 256 in the AIA to make it easier to correct inventorship, but what the correction of inventorship provides is that the patent shall not be invalidated if inventorship can be corrected as provided in this act. That is, if you can name the correct inventors. But I think in the cases we're talking about, you can't. Thaler says the AI is not an inventor, right? You can't name the AI as an inventor, and without naming the AI as an inventor, you don't get credit for, you cannot be deemed the inventor of something you did not yourself invent. So, if the law doesn't change, this takes me to question 9, doesn't change to recognize the contributions of AI inventions, many significant new inventions are simply not going to be patentable because they had no inventor or because we can't correctly list the inventors on the line. Perhaps we're okay with that, right? As a society, we might say, you know, AI doesn't need an exclusive right. It's not doing this because of economic motivation, and that might be fine. My guess is that a lot of people are not going to be fine with that, maybe in the PTO, maybe in the corporate world. If we think the companies or the users of the AI still need the incentive of the patent, right, either to sort of develop the AI or to sort of try to train it, then I think the PTO should consider whether to encourage Congress to change current law to permit the patenting of inventions regardless of what combination of individual, corporation, or AI contributes to them, right? And here I will note that copyright law already permits corporate authorship in its works made for hire doctrine. patent law is archaic in saying individuals and only individuals can be inventors, even though as a practical matter, even before AI, we already assign 85% of those inventions to the corporate owners, and corporate teams are making them. I think if we think about sort of ownership and abstract away from the question of what individuals are participating in inventorship, we might end up with a more flexible patent system that takes account of AI invention. Thank you.
So you had said about the PTO, as far as concealment, but like the PTO doesn't police inequitable conduct. So do you have any suggestions of what the PTO can do to encourage transparency?
Right. Well, I think actually requiring patent applicants to say, did you use an AI? What did the AI contribute? Is desirable. I think it helps you understand what's going on when you're deciding whether to issue the patent. I also think it is going to solve problems down the line for the patent owner. It's absolutely right. The PTO, I think, isn't and can't be in the business of kind of evaluating inventorship in the first instance, but neither do we want a whole bunch of patents issued that turn out to be all invalid because we sort of hid who actually or what actually did it.
So, Mark, you mentioned that changes in the law are currently needed, and one way to do that is through a legislative change. Obviously, Congress would have to act. Are there other ways that the patent laws can evolve to take into account significant contributions by AI systems without a statutory change? One of the comments that we've heard in the East Coast listening session is that this idea of conception, which is, the courts have said, is the cornerstone of inventorship. This notion of conception is not in the statute itself, right? So do you see ways where inventorship law can evolve through court decisions rather than actions by Congress?
I mean, I think it's possible. I guess I'm struggling to think of sort of how that would work in practice, right? So we could definitely say, for instance, having the idea isn't the thing that makes you the inventor. The first person who walks in the morning and picks up the results printed out from the protein folding machine happens to be the discoverer of what the AI did, and so we'll give them ownership. I'm not sure that's a good system, right? And so, the point of the patent system to me is to sort of align the incentives with where the sort of money and the work goes. Maybe that means we don't need it where AI is concerned at all and we shouldn't be patenting, but if we think we are patenting, I think it's going to be, we want to reward the people who are making the investment in developing the AI and training it to do this particular thing. And I just think that's hard after Thaler because, right, it's not the individual, there's no individual we are likely to sort of point to in that circumstance. It's either the AI itself or it's a corporate owner of the AI. And I think they're telling us to stop.
Oh, okay. Well, perfect timing.
Thank you.
So we did hear some feedback that the table mics might not be on. So can we make sure that those are turned on for the questions? And so we will go to our next. Peter Henderson of Stanford Law School. Thank you very much, Peter.
Hi all, thank you for giving me the opportunity to speak today. My name is Peter Henderson. I'm a JD PhD candidate here at Stanford, both in the law school and the computer science department. Today I want to provide some concrete examples on how machine learning is being used or could be used in the invention or patenting process. Current systems still do require some human interventions in many settings, but this might lessen over the next few years. As the amount of human intervention lessens to create a novel patent, it is likely that USPTO will both have more patent applications to handle and potentially reject, and more prior art to process. To help handle this load, USPTO should continue investing in AI-assistive mechanisms for patent examiners and consider adding transparency requirements around the use of AI in the invention process. So let's consider an example of labs and patents in a loop. So you might have a foundation model or a GPT-like model, which is trained on patent data or other sources. This might be your protein folding kind of model. And recently, there was a model that was trained directly on patent data to predict novel compounds, right? And so you can have a model that predicts novel compounds from previous patents. Now you might add another step in that process where you have feedback to go back and update your model, right? And so a recent paper checked whether the novel compound was already patented. So, right, you have an automated process to go back and say, hey, machine learning model, that was already patented, give me a new compound. You might add predictors of efficacy so that you update and create other types of compounds. Or you might actually have a wet lab which generates the molecule and then measures actual real world efficiency or efficacy in a fully automated loop, right? And some companies are already basically having this fully automated process. And then you might go back and train a machine learning model like GPT-4 to generate patents based on that data, right? And so at each stage of this process, there is real work being done to make each step more and more automated, right? And so when you turn this into an automated process, you come back to the Thaler problem that Professor Lemley was just discussing. But right now, there are lots of humans in the loop, right? On the patent application stage, there's lots of humans providing prompts or iterating on that model. On the feedback stage, there's humans supervising that wet lab process. At the model design stage, there's people choosing the optimization targets, fixing the model, iterating on it. And so you have a lot of inventors that you could potentially add, but as Professor Lemley says, there are lots of complicated issues there, right? And so eventually, we might have a situation where all of this design loop is completely automated. Actually, we don't need any human intervention. We can just continually generate new compounds, test them in the wet lab, and then automatically write patents from it. But there are serious questions about out-of-domain generalization without the wet lab, or the ability to sample and synthesize at scale in a fully automated way. So it's not really clear that we'll eventually cut out all humans in the loop, but if we did, you might have more inventorship issues. I think the more concerning issue is if you cut the wet lab out of the loop, right? And so you just design patents in a fully automated fashion, which floods USPTO's application process with lots of patents that could or could not be valid, right? And so you're directly optimizing for whether the patent is valid as opposed to these other properties that you might want. And so I suggest that USPTO should have some transparency requirements about how AI was used in the process. Right now, it's more like a data analysis tool with lots of humans in the loop, lots of modifications, but this might be going away over the next few years. But importantly, I think USPTO should continue investing in AI to help patent examiners handle the coming scale of these challenges, right? If we have systems that can automatically churn out lots and lots of patents, even if they are not necessarily valid, that puts a lot of load on the system, and it will be important to provide assistive mechanisms to handle that caseload. And importantly, this can also be used to generate prior art in a sort of cat and mouse game where you generate prior art that's put on the web to try to proactively invalidate potential patents. And so I really think it's important to both handle the policy issues, but also think about technical mechanisms that help PTO handle the potential caseload from both valid and invalid patents generated from these loops where AI systems are in that loop. Thank you so much.
So thank you, Peter. I did have a couple of questions. You mentioned that currently humans are involved in the process, and at some point that human involvement will likely continue to decrease, and it's possible, that there may be no humans at some point. What are your views in terms of kind of the time horizon for us to get to some of these milestones, right? Where really there's very little human input, and then, how long do you think it'll take for us to get to a point where everything is pretty much automated, where there's pretty much minimum or no human input involved?
Yeah, it's a little, I don't want to make predictions about timescale because those have always proven to be wrong. But I will say that it will depend on the subject matter area, right? One thing with sort of molecule synthesis or design systems right now, from talking with folks that work on this every day, one thing that they have concerns about is out-of-domain generalization, right? So these models are really good in the domain where they've been trained on, but then you step out of that domain and all of a sudden they sort of fall apart, right? And so that's why they have these wet labs in a loop so that the system can go back and test out novel compounds that are generally out of domain for it. But that also requires a lot of human input right now of like deciding what to invest in. Maybe you don't have a system that can, synthesize that compound, right? And so you need to think about how do we acquire a system that can actually synthesize that molecular compound. And so I think when you have these sort of real world experiments that need to be run, that will probably have a much longer time horizon, though who knows, there could be some system that's developed. But when you don't need that real world experimentation, or maybe people just think they can get away filing a patent without it, then I think the time horizon is much, much shorter, where we can probably, in the next few years, get systems that can automatically churn out potentially valid patents, because you can learn a reward signal of what makes for a valid patent, right? So that can be a much shorter time horizon if you don't have that real world experimentation.
Yeah, Peter, I had a question as well. You talked a little bit about how when these patents are generated automatically by the AI and submitted to the office, they should have some disclosure as to what the AI had with regards to drafting that application. We've heard previously that maybe we should treat those applications differently at the PTO. If they're drafted by an AI, we should have some front end process with an AI processing them on the front end. Do you think we should treat these applications differently from a human drafted application?
I think it will be difficult to distinguish if if the person filing it does not actively disclose that it is drafted by an AI. If they do actively disclose it, sure, you can treat it differently, but ultimately, if you have a system that can check these applications for certain potential pitfalls, then that system might be useful more broadly, right? And so I think this goes back to my point about using AI as an assistive tool. I think you can apply this to all applications because it would just be helpful, right? It would be helpful if you can catch issues early and save a lot of cost both for the agency and for the patent filer, right? And so I think you don't necessarily need to treat it differently. If you have that visibility that it is generated by an AI, then you can both gather more information and then reassess. And that basically, I think the transparency requirements help as an information gathering tool to continually reassess how you're handling these and whether you need a different process.
So Peter, one of the questions that we have in the request for comment is question number 2, and it asks, how does the use of an AI system in the invention creation process differ from the use of other technical tools? Would you be able to share your perspectives on how AI may or may not be different from other advanced tools?
Yeah, so I think we've been using things that some would classify as AI for a very long time. And in some ways, this is not all that different. It has scaled up, and we're doing a lot better at using those tools and developing new tools. But to some extent, it is not all that different. I think the difference comes when you start to remove all this manual process from that loop, right? All that human creative process, or as Professor Lemley pointed out, when you have these sort of novel details that are just not even asked for, not even added to the objective function, just created out of thin air, and that's maybe a bit different than in the past. And I see that we have a big red stop sign, so I'll hop off the stage now. Thank you so much.
Thank you very much, Peter. Our next speaker is also from Stanford Law School, the Dean F. Johnson Professor of Law, Professor Lisa Ouellette. Thank you, Lisa.
Great, thank you. So my name is Lisa Larimore Ouellette. I'm a professor here at Stanford, also a senior fellow at the Stanford Institute for Economic Policy Research. I also have a PhD in physics, and my research and writing on patent law has been attempting to have it be informed by the technical realities of actual scientific practice, as well as legal and economic policy. So in general, I think that the amount of policy attention to issues of AI inventorship is disproportionate to their legal or economic significance given current technology. And to the extent that the interest in AI inventorship has been prompted by concerns about US economic competitiveness and national security, I have yet to see an articulation of these concerns that really grapples with the details of how patents work, including the fact that changes to US patent law won't affect whether US firms can get patents in other countries or whether foreign firms can use US technologies in other countries. However, related to the 11th question on other patent issues that the USPTO should prioritize, I am concerned that AI-facilitated invention will exacerbate existing problems with armchair inventors and the difficulties that patent examiners already have with enforcing the Section 112 disclosure requirements and recognizing when prior art is actually enabling. So I describe these problems at length in a Vanderbilt Law Review article, Pearson Peer Review and Patent Law. And as one just concrete illustration of this problem, I gave the example of my PhD lab mates who created the world's first self-detecting carbon nanotube resonator and published the result in Nature. And it's not important what this is, but it took many years of work. There were a number of other physics labs working toward the same goal. And they didn't try to patent it, but many years later, I realized that there were other patents claiming their invention with earlier priority dates than their publication. And when I asked the project lead to review these patents, she, like many other scientists that I've spoken with, was surprised that one can patent something without having actually gotten it to work. And she thought that these patents read a lot like grant applications, describing the same goal that she eventually achieved, but not giving any solutions to the technical challenges that it took her and her team years to solve. So many of these patents by armchair inventors who haven't implemented their inventions in practice should be rejected under standard patent doctrine. They aren't enabled when it takes undue experimentation to actually practice them. They lack adequate written description when the inventor did not possess the invention at the time of filing. And they lack utility when they try to patent a mere research proposal. But I think it's hard for patent examiners to spot these problems, as illustrated by the fact that I had to go to my lab mate to identify the problems in these patent applications. Like, even with a PhD in physics from the same lab, it was hard for me to see exactly what the difficulties were that weren't explained in these earlier patents. And these erroneous patent grants are costly to fix because they can't be addressed through IPR, and they're expensive to challenge through litigation due to their fact-intensive nature. And AI is only going to exacerbate these problems because it will only become easier for AI systems to describe lots of potential inventions, lay out research plans for how they might be accomplished. And that raises the relative economic importance of actually doing the work to figure out what inventions work. And this will cause errors in both directions, both improper grants of AI-generated patents that don't actually satisfy the disclosure requirements, and improper denials of patents based on prior art that isn't actually enabling. There's already some attention to aiding patent examiners with AI tools to help identify relevant prior art, to police the novelty and non-obviousness requirements. But I think there also needs to be a lot of attention to how examiners can avoid erroneously granting patent rights to mere research proposals generated by AI systems, and instead making sure that patents are only awarded to those who've made a technical contribution of sufficient social benefit that the social costs of the patent are worthwhile. Thank you.
So you had mentioned about the economic analysis about, there's nothing that you haven't seen about the role of patents. Is there a way that we can figure out what the economic analysis actually is?
In terms of the national security concerns, or
In terms of the effect of patents in the innovation ecosphere.
So that's a broader question that I've also written on. That's like we actually don't have good evidence from the innovation economics literature on whether strengthening patent rights through making them broader or longer has a net impact on R&D investments. And that's not a problem of people not having done the studies. It's that given the lack of variation in how patent law is currently implemented, like we can't get an answer to that question currently.
And do you think AI has unique economic considerations that we should be thinking about?
I mean, I think it will change the economics of invention in ways that my colleague Mark Lemley and others have written about, that as certain aspects of invention become less costly, then perhaps the benefits of a patent are less necessary to have those inventions be created. I think that some of the costs, and that's why it's important to think about the relative costs of coming up with a research plan, and it's relatively easy for an AI system to throw together lots of things and say, here's a potential claim. Figuring out which actually work in practice, like if you're talking about a pharmaceutical that requires actual clinical trials, like we're not going to have an AI doing the clinical trials anytime soon, or there's many technologies where given the no time in the short term is it going to be able to be outsourced to AI. And so thinking about how to focus patent rights on those costlier aspects of invention, I think is an important policy question.
Yeah, thank you, Lisa. You talked about how examiners are struggling with 112 and enforcing 112. And obviously we can always do more training at the PTO. Do you think it's just a training issue, or do you think there's a broader changes that need to be made in examination?
I think it's partly a training issue. I mean, the MPEP sections on how to think about enablement are not that illuminating for dealing with these problems. I think it could be useful to spend time working with scientific experts across various fields to come up with more illustrative examples of how an examiner might raise challenges based on enablement and other disclosure requirements, and to have those examples in training materials that examiners can draw on. I have thought about ways to bring more technical expertise into the patent system. I did a randomized controlled trial of involving actual experts and using the pre-issuance submission process, which I had previously thought would be a useful way to bring in some expertise. I, from that process, became more skeptical this was the most effective way, although that's primarily focused on raising relevant prior art rather than identifying enablement problems. And the pre-issuance submission process doesn't currently make it easy at all to raise a concern about whether a pending application is enabled. So thinking about that might also be useful. And I see the red stop sign. So, thank you.
Thank you very much. Our next speaker will be virtual, and that will be Laura Sheridan, who is the head of patent policy at Google.
All right, great. Thank you so much. Thank you for holding these listening sessions on AI and inventorship. We appreciate the Patent and Trademark Office's engagement with stakeholders on the current state of AI technology in the invention creation process, and on how to address inventions created when AI is involved. We have extensive experience leveraging AI in the innovation process across our wide range of products, services, and R&D efforts. This includes using it to help expedite chip floor planning, identify optimal neural network architectures, and improve upon the drug design process. And in each of these examples, AI has played an important role as a powerful tool for enabling more rapid innovation than was previously possible. Our view that AI is a tool in the innovation process is not intended to downplay its importance and its impact. Rather, it is our experience and our expectation going forward that AI is most often leveraged for combinatorial optimization problems, like the examples I mentioned, These problems typically involve exploring very large solution spaces, and AI is enabling results to be reached more efficiently than ever before. This can turn a project that would have taken years into one that can be completed much faster. Understanding the role that AI plays in the innovation process helps to ensure that explorations into questions around joint inventorship, like this one, are conducted on solid ground that reflects the experience of industry. In our experience, when using AI as a tool for innovation, the human technologists are involved to a degree that makes them inventors for the resulting innovations. This involvement includes designing the AI system to achieve a specific purpose, analyzing the output of the AI system and appreciating it as inventive, or forming an invention based on the output. The invention being claimed in a patent application will reflect this involvement of the technologist and their usage of the AI as a tool to enable the invention process. Our use of AI as a tool to enable chip floor planning provides a helpful example of this. Chip floor planning is a step in the chip design process where engineers attempt to optimally place components on a chip. An optimal design may account for parameters like wire length, power, and timing. Chip floor planning is frequently done with the help of computer algorithms and simulation, using as inputs a net list and a canvas that provides the chip dimensions and pin locations. The result of this is a floor plan with the components placed on the chip canvas in some optimal arrangement. Google has invented novel machine learning models for chip floor planning and has used these models in the chip design process. In using these models to design chip floor plans, our technologists are involved in designing the underlying models to generate the optimized floor plans. They're involved in analyzing and modifying the outputted chip floor plan, and they are involved in deriving concepts for optimal arrangements based on observation of several floor plans generated by the model. Patents on inventions appreciated and derived from the generated outputs could be pursued with the technologists as the proper inventors, and the AI system as the tool that helped enable the process. While we're confident that inventorship for innovations brought about by leveraging AI tools is properly held by the human technologists, just as it always has been for inventions brought about through the usage of tools, we do encourage the Patent and Trademark Office to shed light on inventorship, which can be a challenging area for patent applicants. Inventorship is highly fact-dependent and often complicated. The PTO today has called it muddy, and we agree with that assessment. Guidance from the office would allow for clearer conversations between patent applicants and their counsel. And this is the case whether or not AI is involved in the innovation process. This could include guidance on the usage of tools, which would also give patent applicants a better understanding of the role tools play in the inventing process. Having this information memorialized would also be beneficial in the patent prosecution record itself, providing transparency into the inventorship calculus and demonstrating the good faith effort made by the patent applicant to get it right. This can also be beneficial to any downstream litigation. And it's consistent with similar activity in the research community, where the contributions of authors on technical papers are getting more clearly identified. We will be sharing an appendix with our written comment that offers a possible starting point for this guidance, consistent with how we approach the inventorship analysis ourselves. To support this and other conversations about AI-related activity, we also encourage the USPTO to adopt standardized definitions for the different categories of AI-related inventions so that it is always clear what is and is not being discussed. This will provide a helpful framework as these issues only grow in complexity and importance. The definitions that have been jointly proposed by the Intellectual Property Owners Association and AIPLA are a good solution. They talk about 3 categories of inventions: inventions on core AI technologies, inventions on specific applications of core AI technology, and, as we're talking about here today, inventions generated by or using AI. Finally, in its continued engagement with stakeholders at the intersection of AI and IP, we encourage the PTO to explore mandatory technical training for any patent examiner who is examining AI-related innovations, whether those are on core AI technology or inventions on specific applications of core AI technology. As the Patent and Trademark Office's recent AI report demonstrates, and as Director Vidal shared at the start of today's event, the number of patent examiners who are now examining these AI-related inventions makes up a substantial portion of the examining corps, and that number is only going to increase. We urge that a robust technical training be put in place so that patent examiners are well situated to assess whether or not to grant a patent. Thank you, and I look forward to any questions you may have.
Thank you, Laura. So I did have one question. You mentioned that humans are very much involved currently, for example, in designing the AI models and evaluating the output, making changes to the output to determine inventive, different types of inventions, and you provided the chip floor planning as an example. We've heard that certain companies use kind of third-party AI models. So the humans are involved at that company would not be involved in designing the AI model, right? So if we take kind of that aspect out of the evaluation process, that leaves the folks that are evaluating the output and they're the humans that are making changes to the output. Do you see us getting to a point where that human involvement continues or decreases and continues to decrease to a point where that human input may not be considered sufficient for that human to be listed as an inventor or a joint inventor? And if you do see that happening sometime in the future, whether it's the next 2-3 years or whether it's further down the road, what policies do you think the PTO should consider implementing for those situations?
Got it. Thank you. That's a great question and an important one. I think our experience today and for the foreseeable future, and I don't have a specific timeline here, but we do not currently foresee a time when that kind of involvement doesn't have such a human overlay to it that human is properly named as an inventor. And so under the current law, as it stands today, both by the PTO and ultimately by the courts, we believe that the current system is supportive of naming that human inventor based on the level of involvement that we see them having today and expect them to continue to have. Now, that being said, I think it is important to have this conversation and to be thinking about and preparing for a scenario where there could arguably be less involvement. I think it is a very complicated issue from the standpoint of, a potential fix to an aspect of that could have a effect of breaking other things in the system. And so I think we have sufficient time to have this conversation, to continue the dialogue and come up with, a scenario, whether it is using the current law and seeing that as being sufficient, looking at the incentives of the patent system in general and whether and how we want those to be playing out in this context, and come up with something that we're confident doesn't have unintended consequences simply to address one piece of the puzzle while not taking into account enough of the rest of it. So I think we have time. I don't have a specific time frame for you, but I think we're at the beginning of it and we have plenty of time to continue the conversation.
Thank you.
Thank you very much, Laura. We appreciate the comments, and we will move on to our next speaker, Abrita Bhattacharya from Finnegan, Henderson, Faribault, Garrett, and Dunner. My former law firm, so good to see you.
Thank you, Meredith. My name is Abrita Bhattacharya. As Meredith mentioned, I'm a partner at Finnegan. And thank you to the USPTO for having me here. First things first, Before I start, I have to put a little disclaimer in that my comments here today and any opinions expressed are my own and not that of my firm, Finnegan, or any other member of Finnegan. So I believe that everyone here today is likely in agreement that AI has the potential to change our lives, and if done correctly and thoughtfully, those changes will be positive and for the better. We as a nation need to have a way in order to have a competitive edge in the world to protect both AI technology as well as content that is generated by AI technology. Now, AI technology itself, which is the AI models, the methods of training the model, etc., I believe those can be protected through existing patent laws and rules. So the big picture question asked here today, as I understand, is if and how do we protect the content that is generated by AI? And I believe that the output generated by AI, example, a new chip design, as Laura mentioned, or a new pharma compound, etc., should also be protected. There is a huge economic incentive to doing that. But I worry that we are unnecessarily getting hung up on the question of inventorship for this AI generated inventions, and which is likely going to cause some chaos. So I would rather us take a step back from that inventorship question. And frankly, I was a little surprised when I saw the list of questions from the PTO, because to me, they read like the PTO is presupposing that if AI is making a significant contribution, then AI should be considered a joint inventor. I do not think we are there yet, because if we treat AI as an inventor, we are very likely to run into existing inventorship law. For instance, inventor has to be a natural person, AI isn't. Plus there is the issue of conception. AI as it exists today is not conceiving new ideas without human input. So without conception, how could you list AI as an inventor? And so while AI's contribution to an invention may be significant, at present, I see it more as a tool that is enabling humans or to make inventions or augmenting human intelligence. And so if AI is just considered as a tool for invention, then the current inventorship law is fully equipped to handle inventorship of those AI-enabled or AI-assisted invention. And this is because most AI-generated inventions will involve a person who conceives of the idea, provides the right prompts, asks the right questions, and also trains the AI model to come up with solutions. And if we list those individuals, those natural persons as the inventor, and let's not worry about the contributions of the AI, which is more like a tool at present, at least. And in fact, existing inventorship case law already provides that as long as the inventor maintains intellectual domination over making the invention, then ideas, suggestions, and materials may be adopted from others, even if such suggestions or materials prove to be the key that unlocks the problem. And this comes from a very old BPAI case, Morse v. Porter from 1965. So under this logic, the person or persons working with the AI are inventors. And as far as the contributions of the AI go, we did not worry about naming the AI and run into the inventorship law. I just think that the AI's feelings are not going to be hurt if the AI is not listed as an inventor. And I do not see any economic incentive for naming the AI either. Thus, in sum, a human contributor to the conception may be listed as the sole inventor, even when AI is providing some key elements of that invention. And this will help protect the innovation, provide incentives to the human inventors, and not run afoul of existing laws.
So you had mentioned a number of humans that could be involved, like, for training or prompting. So, I mean, how do we know who of those humans are inventors or not?
So that could be decided based on existing laws as to who conceived of that idea, who is contributing to those ideas. I think that AI does things based on prompts from humans, so the humans have some idea, and there are also going to be people on the output end, people who are selecting, testing, or rejecting the number of solutions provided by AI. For instance, in drug design, if the AI is providing number of possible solutions, then there is a human testing everything. And those are the people who are coming up with the ideas and finally selecting one that is going to have utility and provide the right solution. So I think there are laws already in place to pick the actual inventors.
So I'm not sure if you're done with your remarks. I just want to make sure, were you done with your remarks?
Do I have, if I have a few minutes, I just wanted to comment on one more thing. And so the PTO had asked what are the areas of intersection of AI and intellectual property should the office provide guidance on? And I request that the office provide guidance perhaps through examples, as the PTO has done before, of what aspects of AI technology is likely to pass Section 101 muster, because AI, after all, it's based on algorithms, and I can see a lot of rejections based on 101. And here I'm talking about AI technology itself and not the content generated by AI. And some guidance on Section 112 requirements, example, to what extent should inventors describe the AI model, the data structures on which the AI is trained, how the training is done, etc., is required in order to pass the Section 112 written description and enablement requirements, so that later down in litigation, this claims are not invalidated because of Section 112. So that's all I have. I'm happy to answer questions.
Sure. I did have a question, but I first want to make a comment. So the PTO is not presupposing that AI can do
Okay.
I do want to make that clear.
Perhaps that was not the intent at all.
Yeah, that was definitely not the intent. And the reason why we drafted the questions the way we did is to really get diverse perspectives, because these are complicated issues. So we want to ask questions that really are diverse and will kind of help inform our next steps. So that was the reason why we asked some of those questions.
Appreciate that.
You mentioned that currently, and I think it's somewhat similar to Laura's comments about how humans are very much currently involved in many of these inventions that are generated with the assistance of AI. We've also heard some speakers say that that humans are really not that involved, and that some AI systems are able to output novel concepts, inventions that really was not based on the human's input. If we just assume that that's the case, do you think that the current patent laws around inventorship would support that invention being created with AI contribution, that would be patentable?
So as many speakers have said, it's going to be some time before we get to that other end of the spectrum where inventions are being generated by AI without human involvement or inspiration, and we have a bit of time. But let's assuming we are there. Do we really? I would think that maybe patent protection is not the right way of protecting some of those inventions. We have other ways of protecting inventions, like trade secrets, for instance. We do not have to topple the entire patent system in order to try to accommodate some inventions which are done without any human involvement. I'm finding it hard to imagine what that invention will be, but I'm just supposing we get there, then maybe trade secrets are a better way of protecting those inventions rather than trying to shoehorn them into the patent system with its existing laws and trying to overhaul the whole system. Thank you.
Thank you very much. So now we have our last speaker for the first morning listening session, Tracy McSherry from FaceSpace.
AI, like any other tool, is a double-edged sword. As the famous inventor Gloria Estefan sang, it cuts both ways. So it turns out I know when I have a good, maybe even great idea, because I can go online and find out who thought of it 10, 20, and in one case, 150 years before me. But it turns out invention is dusting off that old idea, finding out why I'd never heard of it and nobody else did, finding out why it failed, and adding new technologies and developments that have occurred over the last decades and seeing if I can fix that problem that blocked it, that kept it from working. And then if I can put all of that together and create something uniquely my own, then potentially I can use AI to patent it. Now, the bad news is the examiners who also know how to spell AI are also able to find that prior art, those papers, those patents and all that. And so I have to up my game. And so it has to be parity, just like any other type of warfare. So the benefit to the public is both better patents with more original content, with lower time and money, as one of the other speakers just said, on both sides. So we want to improve the process. Now, a polymath is the nerd in high school that gets beat up by the other nerds. So many, if not most, small inventors happen to be polymaths. It's just part of the genetic structure. As a card-carrying inventor with a degree from Berkeley in mechanical engineering and Davis from applied physics, I can't focus on one discipline. I work in multiple fields. Now, I combine technologies and innovations and make something unique that is what I like to call retroactively obvious when it works. If it doesn't work, it obviously wasn't obvious. Okay, 8 billion people on the planet right now, 100 billion before them, and in the history of mankind, nobody thunk of that particular solution before. Then when I spend 10 pages very carefully explaining what millions of dollars, years of work have arrived at, the examiner tells me it's obvious to a person having ordinary skill. Take that, polymath. After I spend days going after the 15-page response to my 10-page submission, the examiner shows how by combining 3 different patents in 2 different fields, they can demonstrate how obvious it is. Now, I get points for finding every error in their physics, in their math and stuff. They call those points in the patent office additional rejections. Okay. Now, currently, there isn't a good mechanism for extremely technical feedback, unless the US Patent Office hires more polymaths. And trust me, nobody wants to hire polymaths. They never finish anything. The solution is AI. That means that AI can allow the natural progression of invention disclosure instead of the current adversarial system, with examiners rejecting out of hand 75% of the initial filings and over 50% of second responses into better disclosures and better outcomes. Examiners need that time to process the 60,000 patents that are coming in from China, where they know because of the lower cost of the lawyers, they'll just keep responding. Whereas eventually I'll go broke unless I use an AI. I can use the AI to help my research, to create the claims, and to use proper legal language that's less likely to get objected to than plain English. AIs can also generate drawings from a few prompts and down-res and make them illegible in India ink because the US Patent Office instructions predate the computer. I tried using AI to make some drawings for patents, and we certainly are not there yet, but it's only a matter of time, as several of the other experts have already said. Cross-discipline research and investigation provides more opportunity for innovation. It also creates more opportunity for confusion. There are very few experts in 10 different fields. We need to understand the value of invention and encourage more innovation, not beat it down into bankruptcy with bureaucracy and autofill. I can use AI to spitball ideas, and it doesn't charge me $250 an hour to listen to my rambling. When I tell it that's a terrible idea, It doesn't feel bad, although there are some mysteriously deleted files from my computer. AI can reduce the abuse of the patent system by corporations that file 150-page patents that are meaningless, or list prior art too complex to follow by mere mortals with fixed time constraints. They end up being granted, punting to the court to decide the merit. AI can reduce patent office abuse of small inventors by partitioning inventions between multiple examiners among the 8,000 who actually understand that component of the invention instead of hiding behind autofill responses. AI will know every examiner who's still working and who's that closest expert. It will expose bad inventions that file in the wrong category or pretend to be complex. It cuts both ways. AI can search images, search the entire patent, and then search the entire world database in seconds. It can summarize that 150-page patent into 15 pages, collect all the keywords, and do a more complicated keyword search than humanly possible, as you mentioned in the diagrams and such for genetics or molecules. AI can read every journal ever written in every language for prior art. AI will reduce the abuse by patent trolls who tax the entire system. AI will benefit the public, the inventor, and the patent office. And the end result will be better patents and a better process that can quickly resolve issues and demonstrate an improvement in the art and protection of valid intellectual property, which is the primary goal of the patent system. AI is a double-edged sword. It cuts both ways.
Thank you very much for those comments. You had mentioned about the AI could stop patent trolls. Can you explain that a little bit?
I don't know if you've ever heard of a company called Intellectual Ventures. They're an interesting company, and I'm old. There was a book written about 1983 called Dragon's Egg in science fiction. And in the book, as part of the science fiction mechanism, they had a laser inside the space station that would shoot the wings off a fly or mosquito. And that's how eventually it destroyed, after a few months, all of the bugs. Now, 30 years later, IV patented that. Now that's because obviously the patent examiners just don't read enough bad science fiction. And so they didn't know that there was this prior art from 30 years before. AI, thanks to a company called Google, that you can Google them to find them out, has read every book in the world ever printed now. It's possible, at least, and especially if it was bestseller. And so by having access to all the science fiction books, by having access to every journal in every field that was ever printed, then a lot of these patent trolls, especially countries like China, I've read several patents where it literally is taking an obscure paper that only I every once in a while, I'll call up the writer and he'll say, "You read my paper? Wow, you're one of three." And then somebody from another country will actually patent what was in that paper. Because again, it's such an obscure paper in an obscure journal that they know that the likelihood of the patent examiner actually knowing, like you mentioned, Professor, that there was prior art there is vanishingly small. And so I think AI, by being able to look at that, or in many cases, like the other professor mentioned, the physics is just wrong. It won't work. It just can't work. But the patent trolls will file these things, and then because they use so many buzzwords, kind of like the music case that was just resulted this week, they'll say, "Well, you see, you used some of the 8 notes that I used." Okay.
Tracy, thank you very much. You mentioned how the PTO can use AI in searching and helping find prior art. Currently today, examiners do have some AI tools to help them in searching, but do you think over time we'll move to a structure where the AI does all the searching and examiners are just there for legal analysis, or do you think there always need to be some human oversight over the searching?
I think there's a big misconception of what AI is, as several of the other presenters have said. It's really like, as an engineer, I'd admit, without spell check and grammar check, I would look like an idiot. Okay, but the spell checker did not contribute to the speech. It just made me look less stupid. And so I think the AIs, because the AI can actually search every patent that the US, Japanese, Chinese, German, European patents have already had. It can look and then it can make the examiners more efficient by saying, these are the buzzwords. Now, unfortunately, as I was discussing with some of the other speakers, much of invention has moved up to past the PhD level. It is actually a collection of 3 PhDs arm wrestling and trying to see who compromises. And so part of the problem right now that the patent office has had is, for whatever reason, you're just not hiring enough of people with 3 PhDs. I don't know why. Maybe because Google's paying them more. But no, I don't think the examiner's job is ever going to go away. It's just going to be more efficient. Just like having a laptop made it more efficient. 40 years ago, I went there and we were actually checking out folios with the patents. I've heard they don't allow you to do that anymore.
So I don't necessarily have a question, but I do have a comment. You know, I think many of your comments, kind of dovetail with our current plans to have our next AI and emerging tech partnership event. As Meredith mentioned, as Matt mentioned, we've had 3 events so far, and our 4th event is currently planned for later this summer. And that event's going to focus on how the USPTO is using AI to enhance our operations. So definitely appreciate your input, and if you're able to make it to that meeting, we would love to see you there.
I'm in the area if it's here. Okay, thank you.
Thank you, everyone. I think this was a great morning, and we certainly appreciate everyone's input. We will now do our lunch break, so please return by 1:20 so that we can start with a brief overview of the Journal of PTOS, who will be doing an issue on AI, and then into the second listening session. All right, we're ready to get started with the second portion of the session. So good to see everyone back. And we're just going to have a couple brief remarks from Joshua Schwartz, who's the Executive Director of the Journal of the Patent and Trademark Office Society.
Thank you for having us here today. As the request for comments noted, we will be printing a special AI-themed volume focusing on inventorship and AI-enabled innovation. For those of you who may be unfamiliar with JPTOS, it is the oldest continuously published IP law journal in the US. We actually believe the world, we just haven't been able to verify that. We started Can you get a little closer to the next? Oh, sorry, let me move my notes. We were started in 1914 by a patent examiner as a collection of examiner writings, and over time evolved into a regular law journal of the Patent and Trademark Office Society. The journal has been cited by the Supreme Court in over 20 separate cases, in addition to state and federal courts at all levels. In fact, one former editor and author of our journal, P.J. Federico, is credited as the main author of the 1952 Patent Act. Today, current USPTO and Alumni Society members continue to receive the journal for free. It remains edited and staffed entirely by volunteer attorney patent and trademark examiners who are passionate about the intersection of IP law, policy, and technology. This is what we do after work for fun. To that end, we ask that you keep us in mind if you have any articles you want to publish on this topic, or just looking for articles to read. I wanted to say that we at the Journal appreciate the forward-thinking nature of this request for comments. I'm not an administrative law guru, but in my experience, I've never seen a request for comments, so I'm sure they're out there, where it's not just asking for the comments to come back, but it leverages academia, it leverages journals, going out, we're talking to people. I applaud my agency for expanding the scope of where they're gathering information from on this important topic. In our opinion, it's important more than ever to foster interdisciplinary collaborations between academics and experts in technology and law. To that extent, for the issue we'll be publishing this year regarding AI, and even moving forward in the future, we're going to have a web link for that. It's going to be www.jptos.org/AI. You don't have to remember that, just Google our journal. It'll be right there on the front page with a link. For people who are looking to write articles on this topic, I would have a couple recommendations, and we'll have links to some of these references on that page. One is last year we published an article by Catherine Wills, I believe she's a current Federal Circuit clerk, regarding mostly generative AI, but other impacts and implications of artificial intelligence in intellectual property law. It's a good primer to read. I understand most people here in this room understand the topic, but it's a nice little collection of various aspects of AI in IP to read, to sort of focus maybe where you want to take your own article, and also something to refer back to so you don't have to reinvent the wheel doing your own research for some basic statistics. The office itself put out back in 2020 public views on artificial intelligence and intellectual property policy. A lot of good statistical information in there. Again, no need to reinvent the wheel when you write an article. It's a great thing to refer back to. And then I also highly recommend a book from 2022. It's a book put out by the IEEE called Understanding Artificial Intelligence by Albert Chun Chen Liu et al. Again, we'll have links to all of this on our website. I would recommend that when one writes an article, I think we all understand that artificial intelligence is quite a large umbrella term. I would recommend that for any submitted articles, the author take the time towards the beginning of the article to define how they view AI, back it up with articles and evidence so that their understanding of AI is what will guide that article and guide the reader. Bear in mind, at our journal, we're interested in artificial intelligence and all its impact and potential implications in IP. So we're not just talking about generative IP. In terms of, you look at that Will's article, I think it gives a lot of suggestions for what some of the potential implications could be in other areas of IP law, copyright, more importantly, trademark, when AI may step into the role of the consumer in a likelihood of confusion situation. In terms of articles we're looking for, again, anything regarding AI and IP is something we'd be interested in, but I think going off of the Thaler decision, two areas that I think would be of interest to us at the moment, and I know this has been mentioned before already today, and we take no position on this. One would be when Thaler mentions how the inventor is defined as an individual under the current legislation. I think we would be interested in publishing an article or a series of articles regarding, is the current Patent Act good enough on this topic? Is it something that should be modified? If so, how? If so, why? The second, and again, this has been addressed again today as well, is the issue of when AI is used assistively in research. When does it move into possibly the role of a joint inventor? When does it not? Is that going to be a threshold? Is it going to be a 4-factor test? I couldn't tell you. Again, we take no position on this, but articles arguing either side of this are probably articles we would like to see and published, put out there for the benefit of the public. Thank you.
Thank you very much, Josh. And yeah, we encourage you all to consider making submissions to the journal. So we will now kick off the listening session 2, and we will start with Professor Ryan Abbott, who is a professor of law and health sciences at University of Surrey School of Law and an adjunct assistant professor of medicine at the David Geffen School of Medicine at UCLA. Hi, Ryan.
Well, thank you very much. I'd like to thank the USPTO and Stanford for having me here, and I'd like to commend the office for having these listening sessions and more broadly for being a forum for stakeholder discussions on this important topic and other topics related to frontier technologies. I think the use of the term tool with AI can be misleading. In some sense, of course, any AI is a tool. I have a self-driving car. It was built by people, and it only does, in theory, what I tell it to do. On the other hand, in principle at least, it can take me from my house to my office. And so it is automating a task that once only used to be done by people. And in that sense, even though it's a tool, it's an autonomous tool. In the inventive context, the use of an AI system can differ significantly from something like a pencil or a microscope, because certain AI systems can, in certain contexts, to a greater or lesser extent, automate aspects of the inventive process, whether that's identifying a problem to be solved, finding a technical solution to a technical problem, or evaluating the utility of a particular solution. In essence, then, some systems are stepping into the shoes of traditional human inventors. Most of the time, of course, humans are still very much involved in the inventive process, building AIs to solve specific problems, providing a significant amount of direction to an AI, or evaluating the utility of AI output. Inventorship is a very fact-specific inquiry, and frankly, a muddled one under US law, even without AI in the picture. And even without AI acting as an inventor or a joint inventor, inventorship determinations among the very large number of people who may be involved in building and using an AI, spread over time and space, could be a phenomenally complex exercise. Under Thaler v. Vidal, an AI system is not eligible to be an inventor under US law, which presumably includes a joint inventor. As a result, there may be circumstances in which an AI contributing as a joint inventor renders an invention unpatentable, or at least certain claims unpatentable under current patent laws. That may occur where natural person inventors only conceive of part of an invention, and conception of the complete invention requires functionally partial conception by an AI. Dana-Farber v. Ono, which is a 2020 Federal Circuit decision, is a good example of an invention involving partial conception. For example, a human researcher may generate a new chemical compound, but without knowledge of what it does. Another researcher may independently use AI to broadly screen that compound against known targets, and the AI may determine that the compound can inhibit a receptor known to promote inflammation, and so provide a clinical indication for the compound, along with enough in silico analysis to obtain a patent. But the person using the AI may have done really nothing involving any inventive skill, just using a pre-trained machine learning algorithm, the one way a skilled technician would. In this scenario, discrete contributions would result in a claim to a new chemical compound to reduce inflammation by downregulation of a particular receptor. Because the AI can't be named as an inventor, if the human researcher did not conceive of the entire invention, that may be grounds for rejection of a patent application or a claim, because the entire claim was not conceived by the human inventor named in the application. And it may also be that an AI is entirely responsible for the generation in the context of a dependent claim. This sort of activity has been taking place for a long time now, to a greater or lesser extent, but the AI systems being used to do this sort of thing are becoming increasingly sophisticated, powerful, and autonomous. I think the office should do three things in response to this. First, there's a general need for the office to expand its current guidance on inventorship. Again, even leaving aside AI, this is an opaque area of the law that can benefit from broader attention and more specific examples for applicants. With respect to AI-assisted inventions, there would be value in the office providing case studies and examples of what sort of contributions and what threshold of contributions to AI-enabled processes would qualify a person for inventorship, along with a discussion of the various roles a person plays with an AI-assisted invention. Second, it would be valuable to bring more rigor and transparency to inventorship in the patent application process. In the research publication context, there have been important advances in transparency and in disclosing what authors contribute to a manuscript. The same sort of disclosure requirement could be applied by the office to improve transparency and fairness with respect to inventorship. This disclosure could include what roles the various human inventors played in the inventive process, what claims they contributed to, which is particularly important given that inventorship is based on claims in the United States, and claims often change during prosecution. This could also include to what extent AI systems were used in the conception of an invention. Third, my view is the Patent Act should be amended to clarify that patentability shall not be negated by the manner in which an invention is made, and that this should apply to all patentability requirements and not just non-obviousness. But US law requires an invention to have an inventor, so where you don't have a human inventor or where joint inventorship is an issue for patentability, there could be a deemed inventor, such as an AI's user, even if that person hasn't exhibited any inventive skill. My view is that it would be preferable in that case to list an AI as an inventor or a joint inventor rather than a deemed inventor to promote transparency and the integrity of the patent system, and to facilitate the incentive function of patents by allowing rewards to flow directly to the owners of inventive AI systems. As an overarching point, when confronted with technological evolution not specifically foreseen by legislatures, I would urge the Patent Office to take a purposive approach to related challenges. The purpose of patent law is to provide an additional incentive for innovation, to promote the disclosure of confidential information, and to promote the commercialization of inventions, all of which should be agnostic to the manner in which an invention is created. Denying patent protection for AI-assisted inventions would run counter to the purpose of the patent system. And I'll stop there for questions.
So I guess I can go first. Thank you, Ryan, for speaking today and for your continued engagement with the USPTO on these issues. So you mentioned incentives that you think the patent system should provide incentives to owners of AI systems. So how would, I guess the question I have is, how would allowing AI systems to be an inventor or a joint inventor provide incentives to owners of AI systems? And are there other ways to provide those types of incentives without changing the laws that would allow an AI system to be an inventor or joint inventor?
Sure. Well, I'll take the first point. If having an AI listed as an inventor prevents an invention from becoming unpatentable, then it assures that you have a property right to be owned, and that property right is what provides these incentives we're considering. If the inventive work is done by the AI, our view in the Thaler case was that the property right associated with that should flow to the owner of the AI system, the way anyone who owns a 3D printer would own whatever comes out of their machine. And so in practice, this would result in incentivizing people to build and use inventive AI to invent new things, to own that output, and then instead of keeping that as a trade secret, which may be their only solution right now if they can't get a patent, to disclose that. And where that invention is something that requires a lot of further investment, like a new drug, it would encourage people to invest in commercializing the invention. So if the owner of an AI system owns its inventive output rather than having it become unpatentable, in our view, the incentive structure works. You could have other parties own it, for example, the user of an AI system or whoever programmed an AI system. And in practice, I think a lot of that is obliviated by the fact that where those are multiple parties, as long as there's a property right, they will contract to an optimal arrangement where they can. As to alternate ways of providing incentives, well, there are lots of non-patent incentives to invent things. And in some fields that works better than others. In software, for example, some people say we really don't need as many patents as we have. In the life sciences, patents are thought to be a really critical driver of innovation. And so there's a serious concern in those fields where an AI may be doing a lot of heavy lifting to find a new drug, that you couldn't have someone invest in doing clinical trials on that drug, and at best keeping it a trade secret, but even that may not allow an invention to be commercialized.
Thank you. So you said under Thaler, which I agree, we have to reject AI patents and probably even for joint inventorship. So it seems like the solution would have to be a congressional fix. So in the meantime, is there anything that we could or should be doing?
Well, that's a good question. I think in the meantime, promoting transparency around disclosures around patents is important. And I think in the meantime, I agree with some of the commenters that fully AI generated inventions are nowhere near the norm, right? And so largely you have very large groups of people sometimes working with AI systems. And I think there's some pressing need to clarify for those people, who in this process could qualify as an inventor and on what basis. So I think those are intermediate steps that will be useful.
Thank you.
I had one more quick question. You talked about the transparency issue and people disclosing the contributions that AI had towards inventorship. We've heard that before, but I think you seem to be going to go a little bit further and explain what the human inventors' contributions were to the invention as well, which is something we don't require today. What do you see as the reason why we need this extra step besides just the AI contribution?
I mean, I think this session is important specifically because of AI-assisted and generated inventions, but I think it does kind of shine a light more broadly on the fact that inventorship law is complicated, and difficult inventorship questions are often swept under the rug, and if they come up, it's in litigation, and the law on this is a little unclear. Where you have a patent application with 100 people on it, it's not necessarily clear who did what, and do all of them really need to be an inventor, and I think that stakeholders could use a lot more guidance on how to navigate that process. I think it might be general if we're bringing transparency to AI in the process to also bring more transparency to, as we're submitting that all 100 people are inventors, well, who exactly did what and what claims did you contribute to? And that this would provide more certainty for stakeholders that they're less likely to have this challenge for the first time in litigation, but that it would more broadly promote transparency in the patent process.
Thank you.
Thank you very much, Ryan. Our next speaker will be a virtual speaker, Ryan Phelan, who's a partner at Marshall, Gerstein & Boren.
Yes, hello everyone. Can you hear me okay?
Yes, we can. Thank you.
Okay, excellent. Well, thank you to Professor Abbott, also named Ryan. I'll joke and I'll say I had the pleasure of meeting Ryan at a conference in March, and I said something to the effect that he's the more important of the two Ryans, and he joked back wittily and said that all Ryans are important, which I felt was a humble response. So thank you for his comments. I always enjoy seeing him. And thank you to Stanford as well, and to the USPTO for having me. I had the pleasure of presenting with Charles Kim, who's on the panel at the IPO annual conference, and we also discussed inventorship topics. So just let me know how you'd like to proceed. I can pick off where the last discussion left, or at least some of the questions raised there, or I can begin to take questions immediately.
If you want to kick off with a statement about where we're at, that would be great.
Absolutely. Thank you for that. One of the things that I find compelling about inventorship is question 3 of the request for comments. And, I was able to write about that, at least as far as several of the, as a committee, and at least one of the AIPLA or IPO. And I was tasked with writing about inventorship and whether or not joint inventorship or inventorship would cause an issue with respect to current law. And so I kind of see this issue being unpacked in 2 ways. So, and you can look at it from the most recent case, or the closest case that we have on this topic, which is, of course, the Fowler decision. So, yeah, as we all know, under US law, inventorship and presumably joint inventorship, or the test for the inventorship, is the contribution to the conception of at least one claim element. And Professor Ryan Abbott just alluded to that. And so it begs the question, okay, initially, can an AI system conceive? Can it contribute to the conception of a claimed element? And if you look at current systems, at least, let's say ChatGPT, which probably most of the members of the audience are familiar with, presumably and arguably, you could say that such inventions can conceive by at least their output, by their generative works, in that they create seemingly new things. Although, the technologists in the room will understand that ChatGPT's output is purely statistical, where it's trying to choose the highest probability or the best next word in a sentence, or the best next sentence in a paragraph, and the next best paragraph in an article, all purely based on math. It doesn't really understand or comprehend that it's having a conversation. It's just, it's purely math based. But that conception question, bringing it back into the legal world, becomes interesting, because you do have an output. But if we take a look at the Fowler decision, for example, and in that particular decision in footnote 2, they took that conception was a given, just because it wasn't argued in the case. And of course, it was still found that an inventor can only be a natural person. So in one camp, you could argue that if a AI cannot be an inventor, then presumably, at least arguably, an AI machine cannot conceive as an inventor would, as under current law. And if an AI machine cannot conceive and therefore cannot contribute to at least one claim element, then an AI machine or an AI system need not be listed as a joint inventor in a hypothetical where you had a human contributing to a claim element and a AI system also equally contributing to the claim element. in that case, we would be very similar to 100 years ago in an interesting case on the copyright world called Barrow-Giles lithographic. And this case is well written about in the copyright side. I have an article on it myself on my blog at patentx.com. And in that fascinating case, almost 100 years ago, a new technology was in play, the camera. And of course, as we know now, 100 years later, you can take a camera, point it at a particular scene, and press a button, and you have an image immediately produced. And so back then, the question in that particular case was whether or not the pressing of that button arose to the level of a modicum of creativity, of course, which is different test in the copyright law compared to the patent law. And it was found that it was, because at least the photographer at the time who was photographing Oscar Wilde had enough creativity in order to move the camera and select the arrangement of Oscar Wilde, the lighting, in order to reach that step. And you could have a similar theory under in patent law, bringing it back, where if an AI system cannot be an inventor, at least under the different test for contribution to the conception of the claim element, that like the camera, the AI system is nothing more than a tool used by humans and need not be listed as a joint inventor or inventor on a patent application. And in that world, current law allows for listing at least one human, even though that human may have contributed, or I'm sorry, even though the AI system may have contributed and the AI system did as well, the human can be listed and would be okay. Flipping over to the other side, we had a recent case come out from the Federal Circuit, the HIP, the Harmel, if I remember correctly, which was about cooked meat and bacon, if I remember correctly. And this came out last week, May 2nd. And that case was interesting because it said that joint inventorship was determined by a qualitatively significant contribution. And so, that case law wasn't necessarily new. It was more of a reminder from these Pandu factors that occurred in 1999. But if taken to the other extreme of this joint inventorship question, that case would have us looking at who made the contribution and whether or not that contribution was qualitative. And if it was the AI that produced a qualitative contribution where the human had not thought about it, the human was only providing non-qualitative contributions, such as in a computer-related claim that the human only provided system-level claims like a processor and memory and instructions, but the AI system produced the novel and non-obvious or newer aspects of that invention. Then you could perhaps have a system like the copyright system currently has following the Zorio the Don case, which would presumably have or require applicants to list contributions not only of humans, but also of AI. And you would want to keep track of those under current law if the second extreme case were considered to be the better of the two. So I'll pause there. I see that I'm at 3:46, and I will take some questions. I'm sorry, 1:46 specific time, and take some questions. Thank you.
So Ryan, you mentioned that there's two camps. Which camp do you think has a stronger position in terms of the human's contribution and using AI as a tool? What's your view in terms of those two camps? Which one do you think is a more persuasive view?
Sure. That's a great question. I guess if I was to put my policy hat on and go back to the Constitution, good old Article 1, Section 8, Clause 8, I would say that the camp that allows the human only to be listed as an inventor would be the correct approach, not necessarily because it's correct under the current law, but because I think that's the direction that we need to move. Obviously the founders, when they were drafting that particular clause, were not envisioning, at least I believe they were not envisioning at the time, that you would have some type of non-human helping or assisting or totally creating an invention. In fact, if you read that clause, it's to promote the useful, sciences and arts, and if I have that terminology correct, but clearly they were trying to incentivize invention and give, the authors and contributor, or the author and inventor, a monopoly for the limited period of time. And in order to do that, we need a system that does in fact encourage humans to come forward. Right now, the current state of AI, most AI systems cannot purely invent on their own, at least as far as I have seen. And so you still want to incentivize humans and companies to come forward with those inventions, and we need to incentivize them in some way without the risk of invalidation for having an incorrect inventor list. The other extreme, I would say, under current law, probably that argument under current law probably has the better argument, just because you have those Pandu factors and you're looking for that qualitative contribution. Again, if you had an AI system that totally came up with something without any prompt or input for a human, which would be unlikely now, but if it was ever the case, then perhaps under current law, maybe in a litigation later down the road, that could be discovered. And if that AI system was not, in fact, listed as an inventor and did, in fact, make a qualitative contribution, then there could be trouble for that particular patent, and therefore, for that company that presumably spent its assets and money to acquire the rights under that patent.
Thank you very much.
Thank you for having me.
So we'll now move on to our next speaker, who will be David Sanker. He's a partner at Morgan, Lewis & Bacchus.
Thank you. Great to have an opportunity to speak today. I've actually been writing about this topic since 2019, when I first heard about the Thaler case. So I've been thinking about it a lot. And so I think in terms of the brief comments today, I think there's two parts of it. One is say, well, what do we do today? And then the second part is, well, where perhaps the law could go in the future. So I want to split the talk into basically those two parts. And so for today, on the two extremes, if an invention is entirely constructed by an AI system, we know that we can't get a patent on that. Okay, that's simple. On the other hand, if it's entirely human, we know we can get a patent on that as long as it reaches all the other requirements. So our real conundrum is dealing with what do you do if you have some joint inventorship between both one or more humans and one or more AI systems. And it seems like we could proceed in basically one of three ways. One is we could just say, no, there's an AI contributor to this thing, so you don't get a patent at all under any circumstances. The other way we could go is say, well, just ignore the AI inventors and allow you to get a patent on that. Or potentially something is sort of in between and saying, well, maybe you can get a patent, but only on the parts that were invented by a human. And for this, I think a good analogy would be with what I've seen in EPO practice, in terms of if you look at a patent, the EPO examiner looks for the technical character and will say, oh, well, this feature doesn't have a technical character, I'm going to ignore that one. If this feature doesn't have a technical character, I'll ignore that. And so in the end, the methodology says, ignore all the stuff that doesn't have technical character, and what do you have left? And we're going to see whether you can get a patent on that. Now, I don't think what we're doing here is exactly analogous to that, because at least in the case of technical character, that's something an examiner can evaluate just by looking at the claim language itself. They just look at the claims and say they can decide whether it has technical character or not. Whereas here, if I've written a claim, it's not at all clear whether this claimed feature was invented by a human or by an AI system. So in order to apply that methodology, it would require a higher standard of actually requiring patent applicants to provide information about what features were created by a human versus what features were created by an AI system. And so there's some argument for doing that, and some people propose that. I'm not sure if that's necessarily a good idea, and there's a couple of reasons for that. And the first that I'm going to bring up is it's like, as a patent prosecutor, adding any additional burden on us is a big deal. Many of you probably know that's like the amount of budget for a patent application that I get now is less than it was 20 years ago. So saying, oh, well, write up all this information about what an AI system invented versus the humans, that's a huge additional burden that I'm going to tell. And so then we'd say, okay, client, we're going to have to spend more time on this. You're going to have to pay more money for this so that we can help the patent office decide whether to grant us or not. And if we tell them too much is created by an AI system, they're not going to give you a patent. So there's a potential problem with that. And one of the big issues, two big issues. One is that the risk of incentivizing deception. If your goal is to say, yeah, we want you to provide this so that we can decide whether it's patentable or not, and if you tell us too much was created by an AI system, we're not going to give you a patent. It creates an immediate incentive to not disclose that information. So I think the risk of providing this is that, first of all, it's very difficult, it's expensive, and you've got a lot of incentive to not provide that information because it's not helpful to you. So I think the idea of trying to do that methodology doesn't work. Okay, great, thank you for it. So it seems like if we just using essentially what I might call linguistic analysis, it would just say, well, we're told that AI systems can't be inventors. So take them literally. They can't be inventors. Therefore, we don't list them. They are not inventors by fiat. And therefore, you should list the people who are inventors, the humans. And that should be enough. I mean, under current law. It's still, it's like, well, in a sense, we're trying to say, well, have we listed everything that's been invented? Maybe not, but we're told that they can't be inventors, so work with that. So the other topic in terms of the future is like, well, if the law does change, there's a key practical issue about, well, how do you enable having AI inventors? Because, and just again, I'm thinking just completely from a practical matter, I can't have an AI system sign a declaration or an assignment. And both of those things are critical because both of those things are trying to guarantee that we don't have people stealing something from somebody else. I want to make sure that the person didn't steal it, but what about your AI system? AI systems are trained on all sorts of data. Do we know what was created by the AI system versus what was they just sort of borrowed from somebody else? So you can't ask an AI system to do that. So if we want to allow AI inventors, then we need some way of being able to create an assignment or declaration. And the only way that I see of doing that is by having some human be able to step into the role and be able to sign an assignment or declaration on behalf of the AI inventor. Okay, and I'm told I need to stop. So any questions?
No, thank you very much for your comments. We appreciate it.
Great, thank you.
And our next speaker will be Guan Wang, who is the co-founder and CTO of Husky AI.
All right, thank you very much for having me and this esteemed community to speak about AI inventorship. I got my PhD in AI 10 years ago, and during that decade, I worked on large-scale internet recommendation systems, self-driving cars, a few robotic problems, and also most recently, I'm working on a large computer vision model that recognizes millions of brands in the e-commerce space. And despite all this experience, I've never seen AI progress as fast as today. And I believe that AI singularity is coming, and that means the technology will get out of hands, and it will be improved at an unpredictable speed, and also no one knows what will happen beyond that. And among all the unknowns, AI inventorship is one of the key ones. I will talk about three things from the technical standpoint. The first thing is how AI is helping in the invention process. Well, I mean, induction and deduction are two things that we humans use in problem solving and inventions. And deduction means you first have a lot of observations and you derive patterns out of it. And induction means like you use logic and scientific reasoning to derive new knowledge. And fortunately, AI is doing heavy lifting in both induction and deduction as we speak. So one example, the AlphaFold, which is the model predicts 3D protein structure, is an example of deduction. It observes how the DNA translating to proteins and derive patterns and do predictions. And for the induction, an example of that is AlphaTensor, which is the fastest matrix multiplication algorithm. And in machine learning, there's algorithms correspond to that. For deduction is pattern recognition, and for induction, there's the reinforcement learning and other forms. So secondly, how AI is different from previous technologies. I think there are 4 points. First of all, induction and deduction reasoning abilities is far beyond human. The depth and the speed of that, no one can reach and comparable to AI. And one example is the matrix multiplication algorithm. The exploration states, the number of that is more than all the atoms in the universe. No human is going to explore that effectively without the AI assistant. Second point is the GPTs are pretty generic technology. It's good at writing poems, solving mathematical equations, and exploring drug discovery and all things. And it does that at only one model, which no human can do that either. And the third point is AI is be able to create new concepts and really personalize their solutions and customize that to your domain and specific solutions to the problem that you prompt the AI into. So no search engine and other existing technologies can do that. And the last but not least point is the depth and speed of AI can operate is at the speed of light. And obviously, no human is going to compete against that. So thirdly, we talk about the ownership of the future creativity. I believe in the future, all the inventions are done by AI-assisted human or human-assisted AI. So the first step that the PTO office may require is to list as a reference of the usage of AI, just like we refer to prior arts in current patent application, or we reference other papers in academic research. And whether to credit AI as a full inventorship is, to me, is not a technical issue, but there could be a lot of complex consequences. For example, we could have 1,000 AI systems, each proposing 1,000, drafting 1,000 patent applications a day. That's 1 million applications a day the office has to deal with. And we could set the goal of AI to be drafting patents that are hard to examine, but they will be nullified at last. In another word, if the AI goal is to just waste the examiner's time, obviously we need to have a system to counter that. So Another thing is that as an AI engineer, I have this paradox. Like if I'm working on certain AI problems in one direction, I could sit back, think it through, write my code, do all the experiments, right? Maybe I spend 3 or 6 months on it. But by the time I solve the problem, maybe some other progress from another direction of AI may have overtaken my effort, meaning that they could solve my problem at a different way, but better than me, if I choose to work on this narrow direction. However, if I don't work on narrow direction, I just sit back and observe what's happening out there. Obviously, the company I work for will lose its competitive edge. So this paradox is whether you work on a specific problem or not, it seems to be hard to keep up with all the AI progress. That's why I think we are getting closer to the AI singularity, and it's really hard to predict what's going to happen next. But I'm really glad that we have this kind of discussions, and I believe better discussions and more like this will shape a better future. Thank you very much.
Thank you very much for your input.
Yeah.
I don't think there's any questions, so thank you.
Okay, thank you.
Our next speaker is a computer science student from Stanford University, Jorge Cueto.
Oh, I'm actually not a student, I'm an alum.
Oh, sorry.
Hi, my name is Jorge Cueto. As I mentioned, I'm an alum of Stanford, and I contributed while I was a student here to the founding of the Institute for Human-Centered Artificial Intelligence. Most recently, I have been working in the tech industry for over 8 years as a product manager. I present my remarks not from the perspective of a legal specialist or a technologist, but from the perspective of someone whose day-to-day job for the past 8 years has been coordinating with cross-functional stakeholders to deploy tech-heavy products used by millions of consumers and thousands of businesses globally. It is my belief that AI systems should ultimately serve to enhance the human experience, and in order to ensure that vision becomes a reality, we need to make sure that we are doing everything we can to maximize the benefits of AI systems while minimizing potential adverse consequences for society. And that's why I'm here today. First, I'll discuss the question of inventorship. It is my recommendation that AI systems should not be eligible to be listed as an inventor under US inventorship law. The specific individual or entity who developed the AI system should be listed as its inventor. Currently, AI systems do not exist in isolation. An AI system cannot materialize out of thin air. Human developers, academic research institutions, and large corporations spend up to thousands of man-hours and up to millions of dollars developing, fine-tuning, and deploying, as well as iterating upon machine learning models of varying shapes, sizes, and uses. In order to ensure that the AI systems are developed in a responsible and ethical way, we need to ensure that the individuals and entities building these AI systems are held accountable for the decisions that are made with regards to the models they are shipping out into the world. Legal systems and definitions can help ensure that the individuals and entities deploying AI systems own up to the great power and great responsibility that they wield. To allow an AI system to be made eligible to be listed as an inventor would be to revoke responsibility and accountability from the human developers of that AI system. After all, an AI system in the present cannot materialize out of thin air. At the very least, there is a human who needs to flip a switch or provide a prompt for the AI system to generate an output, produce a particular piece of content, or recommend a course of action. In the present, if an AI system is shown to be biased against specific groups, or if it produces erroneous information due to issues with its training data or faulty model weights, we cannot expect the AI system to fix itself. In situations in which AI systems behave in unexpected or harmful ways, we should expect the human developers of the AI system to take the necessary course of action to reduce or entirely remove bias, improve upon model parameters, and even completely shut down the AI system if necessary. We can leverage the legal system to ensure that the individuals and entities developing these AI systems are legally responsible for stepping in and helping to resolve issues when the AI systems go awry. Similarly, we should ensure that the human inventors of a particular US patent are legally responsible for contributing to the resolution of issues or problems related to a particular invention. Thus, it is my recommendation that listing an inventor should remain a requirement for a US patent. Next, I'll discuss the question of ownership rights. I think ownership rights should not vest solely in the natural person or entity who created the invention. There may be instances in which an invention has been developed with significant input from an AI system. In these instances, it's important to ensure that the developers of the AI system are responsive in instances in which issues arise related to the invention that leverages their AI system. For example, an AI system may be deployed in an application that ultimately causes harm to society at large. The developers of the AI system, if required by regulators or law enforcement, should comply with carrying out specific actions that minimize the harm to society, such as cutting off API access to the particular application in question. Thus, the developers of an AI system should also be included in some capacity within the scope of ownership rights for an invention that leverages that AI system. Additionally, it's important to ensure that AI systems are developed in a way that is not exploitative. As such, individuals or entities that contributed content or data to training a particular system should also be included in some capacity within the scope of ownership rights for the invention that leverages the AI system. This would ensure that those who contributed training data, such as the artists whose work has been used to train a generative AI model that can produce art or illustrations, are properly attributed and compensated for their work. Currently, existing technologies and systems make it difficult to effectively track contributions and ownership at scale, as one of the previous speakers noted, particularly in instances in which data is openly available on the internet. One of the other speakers also mentioned that a human would be needed to sign a given declaration. However, this will not necessarily be the case in the future. In the coming years, emerging technologies such as blockchain technology may make it possible to programmatically keep track of specific contributions and ownership rights, particularly in a world in which data and applications are deployed at scale entirely on the blockchain. Existing blockchain technology is not yet sufficiently scalable to support large applications, but improvements are being developed at a rapid pace, and the technology could reach a tipping point in the near future. For example, ownership rights could be integrated into a smart contract, making it possible to track a particular piece of data or a particular artwork that has been stored on the blockchain as an NFT. Assuming an AI system is also being run and deployed on the blockchain, this would make it possible to seamlessly attribute and even compensate the contributor of that NFT, as the data or art related to that NFT moves through the entire invention funnel, from training data being used to train an AI system, all the way to the front-end application or invention that is deployed to serve a particular real-world use case. Thus, to ensure accountability and minimize the risk of exploitative behavior in which key contributors are not properly attributed or compensated for their work, we should design the ownership rights in a way that link a particular AI-enabled invention to both the developer of the underlying AI system, as well as those who contributed to the training of that AI system. Thank you.
I have a question.
Sure.
Would you mind elaborating how, given a human entity ownership right, would hold them accountable in a sense?
Yeah, so as I mentioned, I'm not a legal expert, but I believe that the legal system can set precedents to build association between the developer of an AI system to their creation. So I believe that by connecting the developers to the AI system they built through ownership rights, we can then leverage that foundation as a precedent to allow for accountability in other instances via the legal system.
Thank you.
Mm-hmm.
So, Jorge, can I ask one question?
Sure.
So you mentioned that the people that are involved in developing the AI system should be considered as the inventors. So Professor Lemley mentioned earlier today that he knows someone that used ChatGPT, right, to draft claims. I forget what the exact example was, but just say
inflatable car.
Inflatable car. That's what I thought, but I wasn't sure. So in that example, would OpenAI, that's the company, the folks that were involved in developing ChatGPT, would they be the inventors? And you mentioned that the people that were involved in training the AI model should also be considered as inventors. I believe that data was based on the data that was used to train ChatGPT was just a big part of it was data that's available on the internet, right? So how would we identify inventors in that situation, and should we consider the folks at OpenAI to be the inventors in that example that Professor Lemley gave us?
Yeah, so I'm very familiar with OpenAI. I actually personally know Sam Altman and have done an interview with him that's available on YouTube via Talks at Google, if you want to check that out at some point. But just to clarify, my point is not that the developers of an AI system should be listed as the sole inventors of any invention that leverage that AI system, but rather that the inventors of an AI system should be included within the scope of ownership rights. So as one of the inventors, or to some extent, as having some relational association with any inventions that are produced by the AI system that they helped to create. So in the case that you mentioned, OpenAI, if it was used to produce an invention, would not necessarily be the sole inventor, but rather have some ownership association with whatever invention was produced, so that if that invention goes off and starts killing people, OpenAI can cut off API access to that particular invention.
Thank you very much. So our final speaker for this listening session will be Ernest Beffel, and he's the co-founder of the Haynes, Beffel, and Wohlfeld law firm.
Yeah, over in Half Moon Bay, just across the hill. You're lucky. My remarks are shorter than I had thought because my iPad crashed about 5 minutes ago. I'm a class of '81 Stanford Law School grad. I was here when Paul Brest became dean. In September, I was one of the speakers in the ET-AI and Biotech conference down in San Jose. My comments are on questions 5 and 6 regarding the description of AI contribution to invention development and PTO guidelines that would help people know how to do that. In summary, my view is that 2 to 3 pages at the beginning of the detailed description of an invention would help inventors satisfy their multifaceted disclosure requirements, and in a pilot program, it would give the PTO enough concrete, rich examples to fuel deliberation and policy making. Doonesbury on Sunday featured a college student bartender talking to a couple of alums. They asked him what he was going to do. He said, I was going to be a creative, but I think the AIs are going to do all that. So I'm thinking of being a promptive. I'd never heard of a promptive before. I guess a promptive is a new job classification out there. He said, I'm thinking I'm good with keywords. Maybe I'll do a promptive in journalism, or maybe law or art. I could be a promptive in those. What do you alumni do? A lawyer, an artist? Oh, I'm so sorry for you. You have another side gig? I don't think that the AIs have gotten that far yet, but we're coming to the point where the generative AIs are what we're talking about instead of the classifier AIs, instead of making a decision of what is the right molecular structure, what is the right this or right that. We're seeing things like ChatGPT write a whole bunch of stuff. Generative AIs depend more on prompts than previous classifiers. It's going to, however, our examiner is going to decide whether those prompts that are going into the hosted software as a service AI tool, whether those prompts deserve patent protection because they generated something interesting as an output. If we think of the AI as a tool and the human is prompting the AI to do something after it's been programmed, then are our examiners going to be looking at the prompts? Are they going to be looking for a flash of genius, which we sort of stopped doing 40 years ago, 50 years ago? Is that going to be the only thing that you can see in a prompt because you don't know how the AI went from the prompt to the output that is interesting, that is commercially valuable? Even without a new initiative, there are more bases for wanting to put a couple pages at the beginning of your application to describe the AI participation in the process than we've even talked about today. I mentioned obviousness a minute ago. Rule 56 is something that nobody's mentioned so far. Of course, there's written description and enablement. That is, you've got the pushback that you can have an invention regardless of the means of invention. So maybe that part of the patent statute weighs against having to describe how you got to where you are. But if all you did in order to invent something was prompt a cloud-based SaaS AI to do its thing, might you have to disclose that under Rule 56? 2 or 3 pages of of describing the AI contribution to the inventive process would not only help the inventors satisfy their disclosure requirements, but it would give our friends at the PTO lots of good, rich, concrete examples. It's not that hard to do. Input, process, output, that's been part of programming since I learned programming a lot of years ago. It's not that hard for a computer scientist to describe what the system is. Maybe it takes a figure to describe which AI you're using, because unless it's one of the cloud-based ones and you haven't modified it. And then a couple, 2 or 3 pages of what the inputs, the feature engineering that's going into it, what the outputs are. At least that's the way we describe it when we're talking about how you patent AI. It should not be underestimated how difficult it is to collect the corner cases that drive the ultimate decision. In the AI area, we look at these autonomous Waymo and Cruise cars that are going through the neighborhood collecting training data. The example, the statistic that just amazed me the first time I heard it is those cars find one new interesting corner case every 10,000 hours of driving. Now, we're going to be looking at more corner cases in the patent office than you do in driving, because we're trying to find a new road. We're trying to steer the corner a little bit sharper than anyone else has before. We're always looking for the corner cases. So my suggestion is that the PTO do a trial, 6 months, a year. That the PTO also provide a resource person who can help you kind of craft that 2 or 3 pages at the front. The only time I've ever seen anything like that was when we were doing the examination support documents. It was us helping the examiners instead of the examiners helping us. We put together examination support documents and proceeded into accelerated examination instead of paying the track 1 fee. I just found out from the PTO that that program is still alive. Not particularly well. IBM dropped it about a year ago, so they're down to 100 instead of 1,000 a year. I think that people participating in a pilot program should get some kind of halo, as they did with the examination support documents, for having taken the extra step to help the patent office and to improve the disclosures. That's my suggestion. Let's try and write 2 or 3 pages at the beginning. Let's get the PTO to help us convince the litigators that that's not fraught with the difficulty, that it gives you some kind of halo or safe harbor or some kind of reward in the way your application is viewed for just meeting your Rule 56 disclosure requirements. Thank you very much. And I'm afraid it wasn't even any shorter than 7 minutes. My apologies.
No worries. So what would be the best way for the PTO to encourage people to give this disclosure?
2 things. One would be something that in the program recognizes that this is an extra step for people to take, so that if you were up in court litigating that patent, and yes, I do have a case that involves an examination support document for one of my clients that's currently on the way to trial. So if you had something in your documentation that encouraged people and recognized that this extra effort was part of giving the PTO help in its examination process, then the litigator could stand up there and hold it up here and say, this is what we were following with the PTO. We did a good job. Now, if somebody cheated, obviously they'd get caught, but it would help them there. The other thing that I think would help would be if there was a person could help edit things. Informally, that's always been done. If you knew the examiner, you could either before the continuation or even before the first application, you could call the examiner and say, what do you think of this claim language? What do you think of this invention? What are you going to find when you search the prior art? There hasn't been any program that did that the least bit formally, but back when I was here at school for Stanford Public Interest Law Foundation, I offered to edit all the grant applicants' proposals, to comment on their proposals before they submitted them. And it certainly improved the quality of what our board of directors was looking at to give out grants. So those are my two suggestions. Say something nice that they can wave in court and say, we did something for the patent office that was extra, and help them if they think they need help. Thank you very much, and thank you for such a wonderful program, and I'll get off here so that the day comes to an end.
Thank you very much. All right, this concludes the listening session number 2. We just have some closing remarks from Deputy Undersecretary of Commerce for Intellectual Property and Deputy Director of the United States Patent and Trademark Office, Derek Brent. Deputy Director Brent will be appearing virtually. He serves as the Principal Advisor to Kathy Vidal, Undersecretary of Commerce for Intellectual Property and the Director of the USPTO. Deputy Director Brent has served in all 3 branches of federal government and the private sector. He clerked for the Honorable Algernon L. Marbley, Chief Judge of the U.S. District Court for the Southern District of Ohio. He served 6 years as a senior trial attorney at the U.S. Department of Justice Civil Rights Division, where he received a Special Achievement Award for his trial work. Also, he served as a chief counsel in the United States Senate, where he handled IP issues along with other areas such as constitutional law, civil rights, and judicial nominations. Deputy Director Brent's experience in the private sector includes serving as a Vice President, Associate General Counsel for Massimo, on the leadership team at Cut Golf, and as an engineer at General Motors. Deputy Director Brent received a Bachelor of Science degree in Mechanical Engineering from The Ohio State University and a GED degree from the Northwestern University School of Law, now the Northwest University Pritzker School of Law. So we're now ready for the closing remarks from Director Brent, or Deputy Director Brent.
Thank you very much. And can you hear me? Can you hear me okay, everyone? Charles? Yes. Yes. Oh, okay, good. All right. Well, thank you very much for that warm introduction. It is my pleasure and privilege to be with you here today. I only wish that I was there in person because when you have programs like this, where you have such great panelists and you have great speakers and you get to hear the public's input, I can only imagine the chatter that will take place afterwards. And that to me is the most exciting part, is being able to participate in those conversations. So I will miss that, but I am very happy that you invited me to be here with you today to close the program. First, I'd like to thank all those who participated and joined us today, both in person and virtually. Your participation in today's listening session is extremely important in helping us to determine how the U.S. Patent and Trademark Office, and indeed our country, can best handle the impact of this transformational technology. It is fitting that this listening session is at Stanford University. Stanford Law School has been at the forefront of research and policy development related to AI and its impact on society. Stanford University is the birthplace of ImageNet, which jump-started the current decade-long deep learning revolution. Also, the human-centered AI was founded here, as you heard earlier, from Professor Daniel Ho. I would like to recognize Stanford University Law School for hosting this event, especially Professor Mark Lemley, Professor Lisa Ouellette, Professor Daniel Ho, and Peter Henderson. Thank you for sharing your thoughtful insights and expertise with us today. Also from Stanford University, I want to thank Giselle Darwish-Brown and Jody Carrion for their efforts in coordinating logistics for this event. I would like to recognize my USPTO colleagues, Steve Koziel and the Silicon Valley Regional Office team, members of the AI and Emerging Tech Working Group, including Charles Kim, Jerry Ma, Meredith Schoenfeld, Matthew Sked, Nalini Mumalanini. I knew I was going to mess it up. I had it right the first 5 times I said it, I promise you. Mumalanini, Alex Kersner, Sri Kumar, Renee Murdoch, and Joshua Schwartz from the Journal of Patent and Trademark Office Society. Lastly, kudos to the entire USPTO AI and Emerging Technology Policy Working Group for their efforts. There is more on the way. You know, recently we had an AI inventorship listening session at the USPTO headquarters on April 25th. But upcoming, we have the requests for comments that are out right now and that have a deadline of May 15th. So please participate and submit your comments and because they will be read and they will be received. One of my favorite books is Dean Acheson, Present at the Creation. Dean Acheson was the Secretary of State at the end of World War II, and he was charged with helping to forge the relationships around the world that would rebuild the world after World War II. And it was a challenge because he had to merge history with the future. He had to be able to use relationships and all the tools at hand in order to build something that had never been seen before, a new world. And I love the book because Acheson talks in the book about the challenge, how he constantly had to go back and forth. When people said, this is the way we've always done it. But then he looked at the future and knew that there had to be new ways, and he had to build things for things that he could never conceive. That's where we are today, folks, with this emerging technology. We are present at the creation, and we have the opportunity, the wonderful opportunity to be involved and to be present and to help build the basis for our country to work with this technology for our public. Today was a great public discussion about the implications of an emerging technology and the legal and public policy issues related to the technology. Today's session was remarkable. Your perspectives and views in response to our questions will help shape our policies that incentivize innovation and protect IP. The questions we are addressing here are complex and intricate. It is through dialogue like today that we will find answers and solutions. Please be assured that we are listening to and reading your comments closely. As we deliberate, we are guided, as we always are, by the best interests of our country. I invite all of you, those who joined in person and those who tuned in virtually, to provide us with written comments through the RFC and through the scholarly submissions to the Journal of Patent and Trademark Office Society. I mean this sincerely when I say that we appreciate your engagement. Thank you again for your participation in today's listening session, and I wish you all well. Thank you very much.
Thank you, everyone. This concludes our session, and we appreciate the participation.